all be here today with us. We really appreciate the morning start. My name is Nick Rangel. I'm the Executive Director at Legal Aid Society for Northeastern New York. I've not been here a whole year yet, but we're getting there. We have a full day of CLE planned for today and a half day of CLE planned for tomorrow. They are being presented by many incredible panelists, including judges, practitioners, the experts, and our own staff from LASNNY and our board of director member, Kate, and we'll introduce people here in a minute. The program here is brought to you by LASNNY, and if you would like to make a donation or sign up to volunteer with our private attorney involvement pro bono program, please see the registration desk. We do hope that you stay for the entire program, but if you do need to leave, please remember to sign out. You need to sign in and sign out in order to get your CLE credit. You also need to submit the affirmation, which is available at the front desk, and affirm which CLEs you attended for which parts of the day. Dean Carlarn, Congressman Tonko, and Commissioner of Homes and Community Renewal, Ruth Ann Visnauskas, will be speaking at the luncheon at noon. And there will be a networking reception at 4:30 this afternoon. We're hoping the weather is nice and we can extend out into the courtyard. Should be really pretty and really pleasant. Please make sure your cell phones are silenced and calls are taken outside of the moot courtroom. There's an elevator that is wheelchair accessible to my right. There are restrooms on my left that are wheelchair accessible. And there is one at the end of the hallway over here, but it's a smaller space. So I do recommend the ones on the left, my left, not yours. You know, I was writing these and I was like, wait, I remember the moot, is it on the left? Anyway, we do have folks on hand who can help out. If anybody needs assistance, please just let us know. And before we start, I do want to thank Dean Carlarn at Albany Law School and the Director of Government Law Center, the Honorable Judge Stein, for hosting us and co-sponsoring this excellent event. And I'm going to call up Judge Stein to say some welcoming remarks.
Thank you, Nick. And good morning, everyone. It's nice to see some familiar faces and some new faces. Welcome to Albany Law School and the 100-year anniversary symposium presented by the Legal Aid Society of Northeastern New York. As Nick indicated, I'm Leslie Stein. I'm director of the law school's Government Law Center, barely longer than Nick has been with Legal Aid. And as she said, we are a co-sponsor of this program. We congratulate LASNNY on its 100th anniversary of its provision of excellent legal advice, representation, and assistance in connection with matters of extreme importance to individuals and families who would otherwise be unable to afford an attorney, but for the services rendered by the dedicated members of the LASNNY staff and volunteer attorneys. Albany Law School is proud of its students who work with LASNNY as part of their experiential education and pro bono responsibilities. And we are appreciative of the opportunities provided by LASNNY to enable them to learn about areas of law and practice of great significance to persons of limited means. Albany Law School and the GLC are also pleased and honored to have this opportunity to provide a space and other assistance and support for the excellent program being presented here today and tomorrow as part of the 100th anniversary celebration. I wish I could be here for the program. Unfortunately, I cannot, but I am very happy to be able to be here this morning to welcome you all. I know that you will have a wonderful couple of days or however long you can participate in the program, and we hope to see you back other times too. So thank you.
Our first program this morning is on family offense custody and support. Oh my. I'm very proud to present and introduce Joanna Davis. She's one of our managing attorneys based in our Saratoga office. All of the presenter bios are in your material, and we do have a tight schedule, so I'm not going to read all of the excellent work and background that Joanna brings to this panel, but she is one of our foremost experts in the region on domestic violence and family offenses, and we're so glad she can be here. And we have Kate Mastaitis. I'm so sorry. And she is here with Donnellan and Cressman PLLC. She's a partner with that firm and is on our board of directors. We're so glad they can both be here to present this program today.
Oh, so here we go. The running joke at my office is Joanna and technology never mix. I'm like oil and water. So the fact that I have to, I can do it. I can do it. It's fine. Thank you, everyone. Thank you to Nick. Thank you to the law school. It's very exciting to be here, especially celebrating our 100th anniversary. What a milestone for civil legal services, specifically for LASNNY. Just a little side note, Kate and I both began our careers at civil legal services, and we were together in the very early years of our career together in the Saratoga office, LASNNY, and we are just partners in crime. We are good friends, but just we go together like balsamic vinegar and all of those things. I love food. All right. So beginning our, I just wanted to put a caveat because we're speaking about domestic violence in the beginning, especially on a Friday morning. If you need a moment to just take to step out, this is a lot of information, and it can be a little, yes, thank you for the word. I was looking for the word triggering. So if you have to step out for a moment, that's absolutely fine. But we're going to be beginning with family offenses, but specifically with a look into what is domestic violence. So domestic violence, for the most part, I try to use, I try not to default to he or she, but sometimes it does happen. Just statistically speaking, a lot of the crimes that occur are based by male abusers against female victims or survivors. I try not to use the actual pronouns, but sometimes I do slip up. So I will apologize for that in advance. But what is domestic violence, right? These are all listed, are forms of domestic violence: physical, mental, psychological, emotional, financial, verbal, alienation, seeking power and control over their victim, and can also include sexual coercion. These are just some of the elements of what comprises domestic violence. Not every domestic violence case encapsulates all of these different elements, but a large majority is seeking power and control over their victim and do comprise, these are the major elements that are usually comprised in cases of domestic violence. I'm sure a lot of you are familiar with the power and control wheel. It's taught in law schools now, and it's really part of a lot of domestic violence casework. So the power and control wheel, right? It's about keeping that power and control over their victim. The outer ring is comprising of physical violence, sexual violence, and those are the two major elements of keeping power and control over victims. And then inside of the circle is all the different ways abusers will use to try to keep power and control over their victims, right? A lot of times you'll hear your clients say using coercion and threats, right? If you don't do this, I'm not going to do X, Y, and Z. Or the children will be affected, right? Using intimidation, trying to scare our clients, emotional abuse, calling our clients names, using isolation. That is a key tactic that is used by abusers to keep power and control. If you isolate your victim, they have no, way to access any sort of support or help. Minimizing, denying, blaming. You'll also hear the term gaslighting. And again, using economic abuse. That is another key component of violence, of domestic violence in a relationship. If you take away money or access to money or an access to provide resources for your children to the victim, it's going to, again, keep power and control over your victim. So the actual definition of domestic violence is that it's a pattern of behaviors used by one partner to maintain power and control over another partner in an intimate relationship. It may be sexual assault. It could be physical violence. It does not have to be both. And I should have also written in there, it could have comprised of all those other elements as well. And so what differentiates domestic violence cases from what we call stranger violence cases is that that's the intimate relationship, that there is this actual ongoing relationship between the abuser and the survivors themselves. So then what is considered an intimate partner? So what's the threshold for the court? Social Services Law Section 459A and Family Court Section 812 includes family or household members, but also close relationships between partners. So the courts are going to look to the following. Were the couple married or formally married? People with children in common, people who are related by blood or marriage. So that includes in-laws, step family members, people who have lived or currently live together or have lived together, and unrelated people who are in an intimate relationship. The caveat here is there's some connection of an ongoing relationship. For the related by blood or marriage, it can be step parents, step children. It can be just a whole, it's really interesting, and I don't want to kind of go off topic because I love going off topic, but the case law is very interesting and what type of familial relationships are can be found in the courts. So how do the courts determine in the intimate relationship, right? They're going to look to the nature and the type of the relationship. It does not have to include a sexual relationship. The frequency of the interaction, the duration of the relationship, but it cannot be an ordinary business or social relationship. And why we look to these types of, I guess, like why the courts look at this is because teen dating violence is now accessible in family courts and it has been for a while. Children that are 16 and older, because there was this kind of gap in services for teen dating victims, right? They're in this relationship. They weren't able to access civil legal proceedings to get an order of protection. Everything had to go through the criminal courts. And that was a huge gap in services that our legislature finally recognized. And so that's why we look to the frequency of the interaction, the nature of the relationship, giving a little bit more coverage in terms of what resources and civil legal services victims can access. So the family offenses are governed by the Family Court Act, Article 8. They are quasi-criminal in nature. And why we say they're quasi-criminal in nature is because they're concurrent proceedings with the criminal courts, right? The family court registry, the orders of protection, both the temporary and the actual, what we call final orders of protection, but that's kind of like, they range in years of 1 to 5. They all have a criminal component to it. If you violate any of these orders, you can go to jail. Enumerated family offenses are found under Article 8 of the Family Court Act, but they refer to the penal code for definitions and elements that you have to prove for trial. So if you're going to be representing a victim of domestic violence in a family offense proceeding, you have to be familiar with the penal code, right? But the burden of proof in family court is the preponderance of the evidence, which is more likely than not. So I kind of think of it as the best of both worlds, right? We have to refer to the penal code, but there's a lesser burden of proof. So I apologize. I could not figure out how to make the background of this slide match all the other ones, but these are all of the enumerated family offenses that are found within the Family Court Act. Just for time purposes, I'm just going to highlight a few of these. Some of the things that can be readily found in most, if not all cases, are disorderly conduct, criminal mischief, a lot of menacing probably, as well as coercion. You'll find a lot of these cases have these components in common, and I'll touch on why in a little bit later in the slides. So in family court, regarding these orders of protection, what can you request, right? There's a whole bunch of things that the family court allows attorneys to request on behalf of victims of domestic violence, right? So the straightforward ones are the two types of orders of protection. There are stayaways and then there are refrain froms. I'm going to go with the lesser one first, which is a refrain from order of protection. Refrain from orders of protection basically tell an abuser, do not commit any of the enumerated family offenses, right? So basically how we explain this is you shouldn't be doing these things anyway, but now you need a court order telling you that we should not be engaging in these types of offenses, right? Don't hit someone, don't stalk someone, don't threaten someone, all of those things. The stay away is the stronger of the two orders of protection. The stay away will say, you have to stay away from this person. Sometimes the orders of protection will actually give specific distances. And depending on your case, you may ask for specific distances or places to be included. So the stay aways usually will include the home, the school, the place of employment. You can also put in there no more than 500 feet, 200 feet, all of those different types of exceptions. There's also exceptions contained within the order of protection that you can ask for, especially when the abuser and the victim have children in common, right? So they'll say things like, stay away except for transporting the children, for pickups and drop-offs. It'll say no communication except for communicating it via text or email regarding the children. Again, no illegal or offensive contact. There will also be additional provisions that can be included, and we call those the Section 99 provisions, which also include custody and visitation provisions, right? If a client is going in to see a judge to obtain an order of protection, they might ask for custody, and the courts and the judges can actually give temporary visitation and custody provisions within the orders themselves, such as, you know, the abuser shall only have supervised visitation with the children, or we're going to give temporary sole legal, sole physical to the victim. They can also give temporary child and spousal support orders. So if you are ever helping a client that has to access the courts, the fastest way to get in would be to file for a family offense. You can request temporary child and spousal support. The caveat note for that is they must then file for child and spousal support separately. It's not going to be carried through in a specific order, separate and apart without that petition being filed. Our clients can also request a police escort order, and that is specifically giving a time frame for the abuser to retrieve their personal effects. It is not a property distribution issue. It is not where they're going to be able to figure out, oh, you get the couch, you get the TV. It is just for the abuser to be able to go get some clothing, their personal care items, any medications, those types of things. It is not going to cover any of the splitting of household assets. Although some family court judges would like us to do that, we don't. And we likely remind them all the time, like, no. And then firearm retrieval or firearm surrenders. The orders of protection, right? If our clients know what specific firearms are within the house, we can ask for all those to be surrendered, ask for the sheriffs to actually go in and get those firearms and keep it at the sheriff's office to keep firearms out of the hands of abusers. Now, that is with the statement that it's a Friday morning. I don't want to be like super duper like down, but there are lots of ways to kill people. And I'm not saying that flippantly. There really are. So taking the firearms out of the home doesn't necessarily guarantee that our clients are safe. It can make them statistically safer. But just note that there should be safety planning going on. And I'll talk about that in a little bit. So what else can you request in an order of protection or in a family offense proceeding? You can ask for a lot of stuff. I don't know how to do the fancy, like, you know, where the one bullet comes in one at a time. One day I'll learn. But the biggest, oh, really? Right? Pew, pew. So you can request on behalf of your clients, if we're concerned that maybe the abuser has a mental health issue, is not complying with their medication and their treatment, and that might be a source of what is causing the violence in the home, you can request a mental health evaluation. You can also request that any results of the mental health evaluation, including any sort of prescriptions for medication, that there be a compliance with that treatment and compliance with taking that medication. What's really useful is that once any person is undergoing taking medications that are like treating a mental illness, that they're usually also having to see a psychiatrist that has to, you know, do like blood tests to make sure that they're actually taking. the medications as prescribed. You can also request drug and or alcohol testing. I would really strongly recommend hair follicle testing, just because that is the best way to track whether someone is actually abusing illegal drugs and or prescription medications. If there's going to be a request for an alcohol evaluation, you should really be requesting a CASAC evaluation. You can also request a return of specific identification documents under specific conditions that are being set by the court, right? So if we're concerned that maybe there is a household where one of the parents is not a US citizen and there's a concern of fleeing with the children, we can request passports be held in escrow. We can request that social security cards be returned, health insurance documents. That's really hard. We see a lot of fights about, you know, health insurance cards not being exchanged, and then children have a medical emergency, and then what happens, right? If we don't have the health insurance cards, driver's license, clients who may be undocumented and or maybe just permanent residents of the US, their documentation being withheld, employment and authorization documents. These are all very important documents for our clients. And so if there is a way, if there's a concern that these documents are being withheld, we can specifically ask for these things to be returned. There is, I should have put an asterisk here. You can also request batterers education and or anger management. I'm just going to put it out there. These programs do not work, but they are a mechanism to try to provide like an additional step to have an abuser comply with a treatment program in order to gain more access to something else, right? Like such as unsupervised parenting time, those types of things. But these programs do not fix anyone. And any of your clients that are like, but I heard that, you know, it'll make them a person that's going to not like beat me up all the time, and be like, I'm so sorry. I wish that was the case, but it's not. Wow, I'm kind of depressing this morning. I apologize. There's more. Other things that we can also request. I'm like, we can also ask for restitution. I love the Family Court Act. Every year, we get the new ones in January. I read them. I love them, right? We can ask for restitution for medical expenses. We can also request protection for companion animals. A lot of times, right? I don't know about you. I love my animals. They're like my babies. And if anyone hurt them, I would probably kill that person. But what better way to maintain power and control over me than to hurt my animals, right? You can now go into family court, and it's been in place for a while, right? That we can ask for an order of protection to include companion animals. And and I'm talking like goldfish, hamsters, all of that. Right? Children love their little tiny little like rodents. You can ask for those rodents to also be protected, and they should be, because it is traumatizing when that is, when these loved animals are hurt. So what can the court do? I love it when the courts like sua sponte do stuff, only if it helps my client, but it usually does. The courts can also order a 1034 report. A 1034 report is closely linked to Article 10 proceedings, which are like the neglect and abuse proceedings, but they can order a 1034 to be done, basically asking, we want a history of any sort of indicated reports or CPS history of these parties. Sometimes they're helpful, sometimes they're not helpful, but they can do that. The courts themselves can also request that there be an initiation of an Article 10 proceeding, especially if the allegations contained within the family offense petition is so egregious that they're concerned about the safety of the minor children. They can, again, issue temporary support, custody orders, and consolidate the proceedings. I don't have enough time to talk about the whys we would ask for bifurcation versus consolidation. And this is my favorite: transfer or refer the matter to the district attorney's office if the interests of justice require it. I'm not going to lie. I personally love like keeping like a little metric for myself. Like every year I would like to make one case referred to the district attorney's office, right? I feel like that's my tax dollars at work. But I should also say I like to make jokes that can seem a little inappropriate, but that's my like coping mechanism. But to be very serious, just recently this spring, I had a case where I had a respondent on the other side during our actual trial start threatening myself, my client, and then threaten the judge that he was going to kill them. So I got up and I was just like, oh, here's my glory, right? I asked for a referral to the district attorney's office, and I asked for a copy of the transcript, right? The copy of those specific proceedings to be immediately transcribed and sent to the district attorney's office, and for charges to be levied against the respondent. I think that is our due diligence in any way that we can protect our clients, especially from someone who's as bold as to threaten the life of a judge. I was kind of like, wow, you got some chutzpah. So I would just say, this is something that we can do, and we should be asking the court to do it. We shouldn't have to wait for the court to say, what's our threshold? When are we kind of, oh, they might be really upset. Well, you know what? I'm upset a lot. I don't go around threatening people. Just maybe my husband. All right. I really don't. I'm sorry. All right. And then venue, right? So this is like another like procedural issue. For venue, for an order of protection, or for your clients seeking an order of protection, they can seek an order of protection in the county where the acts allegedly took place, regardless if they are residing in that county or not, the county where the family or the household resides, where either party resides, or the residence, including the county in which our clients or the victim is in a homeless shelter on an emergency or temporary basis. So sometimes, it's really unfortunate. I wish there was more resources out there, especially for housing. So some of our clients who are really in serious and dangerous situations might have to go into a neighboring county or even across the state to get emergency shelter for themselves and their children to keep safe. They can file for an order of protection in that county. They do not have to go back to the home county. Some helpful practice tips, right? This is about trauma-informed representation, right? Our clients have been through a significant amount of trauma, and we should be patient with our clients and understand that this is going to be a long process. I'm a fan of pleading as many family offenses as possible. There's a checklist on that family offense, go to town, right? Because you can always amend your petitions thereafter. Usually our clients are working with advocates, so I'm always like, check as many as you think. Know the elements of the crime, right? I always keep a copy of our charts that we have, our interns draft, which are really wonderful every year, just to know what the actual elements are, right? How do the facts tie in with the elements? Physical injuries. Has there been an impairment of a physical condition, substantial pain, serious injury, substantial risk of death, or causes protracted disfigurement or protracted impairment? Dangerous instruments under circumstances readily capable of causing death or serious injury. A side note here, everyone always thinks dangerous instrument, oh, a gun, a knife. I've had clients where, the abuser takes a glass beer bottle, breaks it, and they're able to use that to harm our clients, right? There's like really creative ways out there. So really speak to your clients and really make sure that all of this information is put into a petition. A side note about proving intent, with most offenses, intent can be inferred by the action itself. A lot of our newer attorneys are like, how do I prove intent? I'm like, well, when your client said, well, he drove the car straight into my car trying to kill me, the action itself can be inferred, right? The intent itself is inferred in the action. And that actually just happened to one of my supervisees cases. And I was like, oh my, they're okay. Some other helpful tips: establish trust with your clients. Do not ever promise an outcome. Help determine your client's priorities and not your own. This will be probably one of the first times your client will be able to make a choice for themselves and get some power and control back. We have to be very respectful of those choices, even if we're concerned that it may not be the correct or safest choice. We have to respect it because our clients will know what will keep them the safest. To amend or not to amend, I'm a huge fan of amending petitions. I just am. Safety plan with your clients. If we're already working with a domestic violence advocate, they'll already have done some safety planning, but it's an ongoing process. Your cases are going to probably track 4 to 6 months at least. So we should always be updating our safety plan. Have our clients preserve as much evidence as possible, right? Police reports, medical reports, audio visual recordings, body cams. I love body cams. They tell a lot of information. Also like those videos, those Ring cameras, those are great too. Social media. I love social media. I don't particularly use it all the time, but like I love it when others do because you get a whole wealth of information. And witnesses, right? The old fashioned calling witnesses and seeing what they saw or asking them, what did you see? Trial or settle? Do you want a finding? I love findings. The reason why, and this is just a little hint about bifurcating, is because if we ever do a domestic violence family offense trial first and get a finding, that must be taken into consideration by the judge for custody matters. So that's why I love findings. I promise my last note. So criminal mischief, right? Does apply to property in which the respondent has an ownership interest in, as long as the other person also has an ownership interest. So a lot of times some law enforcement will be like, oh, yeah, this could be criminal mischief, but you both have an ownership interest in this television. When he slammed it over your head, like he could destroy whatever he wants. He owns it. Not so true, right? This is a caveat. Disorderly conduct as a criminal offense only applies to conduct in the public place, right? That's in the penal code. But in a family offense in the civil legal proceeding route, right? The conduct can occur in a private home, right? In the private place, and still constitute a family offense, because if the conduct is capable of causing a public disturbance, right? That meets the caveat of the disorderly conduct. That's why I say disorderly conduct and criminal mischiefs are my favorite. Right? If someone's yelling in a private home, like you're such a terrible word, right? That's going to be a disturbance if it was happening outside. So sorry to rush everyone. If you have any questions, you can always see me afterwards. Thank you.
Morning.
Okay, I was told I'm not tall. I have shoes on that elevate me. Want to be able to see out above the microphone. I trust that everyone can hear me okay? Okay. So my name is Kate Mastaitis. I am a partner with Donnellan Law. I apologize. I sent an old version of my resume. So my firm is Donnellan Law. As Joanna said, we have known each other for many years, have maintained a great friendship. And I sometimes love hearing anything that Joanna says, because after all these years, she can still make me smile. And despite the seriousness of which the topic she was discussing, I always respect her sentiments, candor. And I agree with Joanna. In this line of work, you do need to at times have a sense of humor. We see attorneys burning out quickly if they take on their clients' struggles as their own. Sometimes they'll say, oh, counselor at law. And I think that's a term in family court that can seem so true, but it's so important that we remind our clients that we are their legal counselor and not their emotional counselor. So regardless of whether there's domestic violence or they're just going through a hard time in a very difficult custody case, encouraging all clients to have healthy mental health, preserving themselves, reach out to resources, reestablishing some connections with folks. So I just wanted to kind of add that as I begin. So I am charged with discussing with you on this Friday morning custody under the Family Court Act. Generally, there are two main subheadings in custody cases: legal custody and physical custody. Legal custody has to do with making decisions. I did change this slide. Has to do with making decisions on behalf of the children, general, medical, educational, welfare. This isn't that's not whether or not we're going to pack a school lunch or get the, buy lunch, but rather we are, kid is climbing a tree, kid falls out of the tree. Decision number one, go to the hospital. Number two, do we follow the advice of doctors and get an x-ray? Number three, doctor makes a recommendation. Do we follow that or not? Those are the kinds of things that may seem obvious, but those are all things that we have to consider in the legal custody. And when parents are living apart, communication from the very beginning of that process is important. Courts will look at whether or not the party who is there at the base of the tree is communicating with the other parent. Hey, this just happened. We are going to Albany Medical Center. We're going to be getting in the car in about 10 minutes. And, if you want to meet us there. And then it also falls on the other parent to reciprocate communication if they can. Legal custody is a right, but I think just as important, it is a responsibility. So it is not only the responsibility of one parent to communicate information going out, but it's also the responsibility of the other parent to reciprocate the communication, acknowledge the communication, and how do they participate in that process. More and more, we have parent portals for school. We have patient portals for educational records. Encourage your clients to get on all of those platforms. They have a responsibility to be informed when report cards come out. If in a individualized educational plan, or what we call an IEP, if that meeting is coming up for services in school. And it doesn't all fall on one parent to be the messenger. Report cards came out, IEP next week. Your clients should be taking on the responsibility of being just as involved, whether or not they have equal time, less time, significantly less time. It really is a right and responsibility. Physical custody has to do with where kids live. More and more, we are, at least in my practice area, which is primarily in Saratoga, I see a lot more instances where we're saying shared physical custody. Parents can have primary physical custody. They can have, which means one parent has more time than the other. Shared physical custody used to, I think, implicitly mean it is equal time, but I find more and more that phrase is being used to describe a sharing of time, regardless of whether it is equal or not. Joanna and I can go out and have pizza, and I can eat 5 pieces of pizza and Joanna can have 3 pieces of pizza. It's still a lot of pizza. We shared the pizza. I ate more pizza, but it's still sharing. And so sometimes I think that it's a more kinder, gentler way of describing the arrangement. The label primary can seem really polarizing, and sometimes a label is all that you need. If you shift the label, it can really appease and get a settlement happening, or more discussions with regards to a settlement when it comes to custody. Because for child support purposes, the child support magistrate may consider or shall consider who has more time regardless of the label. So if you are in court and someone says, we should call it shared, the important thing is, what is the parenting time? Parenting time is a subheading. I always describe it as the physical custody part. Parenting time describes what is the schedule that kids are going to hopefully enjoy with each of their parents. We no longer like to use the word visitation. We visit aunts and uncles, we visit grandparents, we visit Disney World. Parenting time means the rights and responsibilities that go along with it. Accompanying kids to their sports, ensuring that kids do their homework. Generally, those are things that aunts and uncles, when you go over for Thanksgiving, they aren't saying, hey, sit down and do your homework. Parents should be parenting during that time. So do stay away from that word visitation, because I think it minimizes the role of parenting. It's kind of a hot button word, at least in my geographic area. The parenting plan is a way to describe what the time is going to be. Make sure that in describing what that parenting plan is going to be, you know the day, the time. Custody orders can say parenting time as can be agreed. That can be a rather difficult thing if we can't agree on the time. At least having a default. Friday at 4 p.m. until Monday at 4 p.m. shall be the father's time, Monday at 4 until Wednesday at 4. So you do want to be specific, because although you might be negotiating a settlement or you're asking the court to apply a certain order after a trial, you want to know when it starts and when it ends. And you can always encourage your client to think of it as a default. If 4 o'clock doesn't work one day because maybe kids get out of school at 3:15, and who's going to go, is it fair to the child to go home to one parent's house for 15 minutes only to have the other parent then pick them up? It can be better if parent number 2 just picks up directly from school or meets kids at the bus. So you aren't having these little transitions, especially if one party is alleging that kids struggle with the transition. Okay. How does the court determine custody? The court considers what is in the best interest of the child. There is no mathematical formula for giving points to parents. The courts have to consider all relevant factors. The allegations that are contained within respective petitions for custody and an attorney for the child appointed, within a petition, you want to be specifically asking for the relief that you're looking for and why. The court will consider what is best. It can consider the past, but also what are the plans going forward. In every custody case, an attorney for the children is appointed. Generally, at the beginning of a case, one attorney for the children is appointed for all of the kids. You really want to explain to your client that the role of the attorney for the child is to advocate for what the wishes that are expressed to them are. There are limited exceptions with regards to that, but even under that exception, an attorney for the child must say, the stated wishes of my client are. However, I am substituting my judgment because I do not believe that my client appreciates the gravity of the choice that they are making or their wishes. Attorneys for the children have to be very careful when they're substituting their judgment. They have to be very specific. And there are cases at the appellate division level that have criticized and reversed cases because the attorney for the child did not sufficiently argue or provide the basis for why they're substituting their judgment. Like Joanna, I don't have great technology skills. What is best interest? The dominant case that we rely on in describing some of the factors is Eschbach v. Eschbach. The site is up there. Which parent has been the main caregiver and nurturer of the child? The parenting skills of each parent, their strengths, weaknesses, and their ability to provide for the child's special needs. If you have a client and the child has special needs, I would strongly suggest that you, at the very beginning of your representation, have releases executed, try to speak with the people, whether it is an educational special need, asking for a copy of the IEP or the individualized educational plan. If it is medical related, do some research, understand what is the nature of the medical issue. Are there medications? Do research to better understand those medical needs, and you may need to educate the court with regards to those things. So if a child has a very specific allergy, you want to understand what is the allergy, what needs to be done to keep that child safe. If the child is on specific medication and it's important that the child take that medication at a very specific time, and you're saying that one parent is not giving the medication as they are supposed to, be ready to educate the court as to why that is potentially causing medical impairment or the lack of medical care is negatively impacting the child. The court can consider the mental and physical health of the parents. If one party is alleging that there is mental health, you strongly want to consider what limitations, if any, do you want to have for getting information out there. Sometimes practitioners will say, hey, would your client be willing to sign this release for their mental health records? I generally say no, and I try to get documentation from the provider to establish, 1, my client is attending. 2, this is how long they have been attending. 3, they are regularly attending. 4, they are in compliance with all recommendations. That's not giving a lot of protected information. I think it provides just enough reassurance that my client is doing what they are supposed to do. If an attorney serves a subpoena on you, there's actually a formal process with regards to the mental health records where a motion must be filed. If a party is not willing to sign a release, the court has to make a specific finding that the need for the records outweighs the HIPAA protected information of those records. So if you are ever served with a subpoena and it is not accompanied by the motion, you can quash that subpoena, filing a motion, basically saying, or just telling the person, I'm not complying with this subpoena. You didn't go through the proper channels. And really that motion, if you can get your hands on one, keep it, because it's a pretty simple motion if you are the party seeking the mental health records. Domestic violence in custody. How does domestic violence affect victims in court? Power and control is held over another parent. Even after parents separate and have separate households, the abuse can continue. If you have a client, if there's a shared iCloud account, you definitely want to encourage your client, tell your client to change the settings on the iCloud account, so that way their messages could not be viewed. You also want to encourage clients, perhaps get a new email address for just you and I to communicate with, or other people that they don't want their abuser to be able to access those emails. Oftentimes, if there is a child that has an iPad and it goes back and forth between parent 1 and parent 2, is that iPad something that parent 1 uses for their emails and then parent 2 can get it? So definitely just ask those questions. How is information received within a household, and how, if at all, do we want to change those devices and those settings to minimize the risk of one parent being able to view the messages of another parent? Financial control. Even if child support and spousal support is ordered, the abuser can still withhold payments as a form of power and control. Certainly, there is an advantage to having the child support collection unit involved, garnishing the wages of that parent. That minimizes it. But certainly, I've had plenty of cases where before support collection unit can get involved, the abuser is writing, allowance on the memo line of the check, or they meet to exchange the child. The abuser says, I don't have it for you today. You'll have to wait. And then 3 hours later, they say, actually, can you meet me? I now have it and I'm 60 miles away. And if your client rather is struggling to pay National Grid, their mortgage, their rent, if they were planning on going to the grocery store while parent number 2 had the kids and they couldn't go to the grocery store because they didn't have the child support, they're going to feel more compelled to go and meet that person, further exposing them to, an interruption of their day, but more importantly, greater exposure to their abuser. So certainly, if it's possible to have the support collection unit garnish those wages, ask for that. It's a way of taking that away, and just it can minimize other interactions at the exchanges if it's just going through directly. There can certainly be continued physical, verbal, and emotional abuse, especially in the presence of the children. If you are facilitating a parenting time exchange, consider where you will be doing that parenting time exchange. Do the parents actually have to go? I always encourage my clients, if my client is the victim, have somebody go with you or have someone else do it. Or if it's going to be unsupervised time, exchanging at the commencement or rather the end of the school day, minimizing the time that the parents actually have to be together at the same place for exchanging the child or children. I wanted to just add, Joanna was talking about orders of protection. And if there is a companion criminal case and there is an order of protection, you want to be mindful of when that order of protection was issued. Oftentimes, a criminal court order of protection may carve out an exception, and it'll say something like subsequent to an exception by family court or Supreme Court. Oftentimes, it'll say a subsequent order from family court and Supreme Court. That word can actually be very difficult to overcome, because if an order of custody is issued on Monday and on Tuesday the criminal case finishes, you have to be mindful, does that new Monday order it's not subsequent to the criminal court order, it's before. So now do you have to go back to family court to get a subsequent order? Speaking with the district attorney to inform them when there are custody orders to make sure that that the criminal court order is not going to actually interfere with the implementation of an order of custody, because a family court order of protection is not superior to a criminal court order of protection. So you just kind of want to make sure that all those pieces are aligned. Joanna also talked about in an order of protection, you can request protection for a pet. Under the Family Court Act, it does not provide for continuation or addressing the ownership of a pet. So the order of protection can say, stay away from the pet. But if there is a termination of that order of protection, it's modified. It doesn't actually confer any ownership in family court. I say family court, I'm emphasizing in family court because actually under the domestic relations law, in section 236B, when you are discussing just the maintenance and distributive award, the property, they actually do provide, it's 236, that the court can, in awarding possession of a companion animal, the court shall consider the best interest of such animal. Companion animal as used in this subparagraph shall have the same meaning as subdivision 5 of 350 of the Agriculture and Markets Law. Basically, a companion is a pet, a dog, a cat, or other domesticated animal. So if somebody has a pet pig, if it's a matrimonial case, the Supreme Court can address the pet pig. Family court cannot address the custody of the pet pig or cat or dog or whatever domesticated animal that is. Pushing this back in. How else? The court can consider the refusal to cooperate in the medical and educational needs of the children. Sometimes the remedy here that the court will do is for legal custody, the court will either award sole legal custody to one parent, which is very difficult, or modified joint legal custody. In the event that the parties are unable to reach an agreement with regards to a decision, certainly if one person says yes, one person says no, that's like an automatic veto. So the courts may implement modified joint legal in the event that the parties are unable to agree on a decision and there's been a good faith effort to communicate, then parent one shall be able to make the medical decision in that moment. So that's something else that can be really important in our custody cases. It's really the tiebreaker. The court can consider the unwillingness to co-parent regarding simple decisions such as school pickup and drop-offs, extracurricular activities, appointments. I always encourage my client, text, if you are the person asking for softball, send a text. We got the flyer for softball. I'd like to register Susie in softball. The registration ends on Thursday. You know, let me know if you have any questions or concerns, especially if Susie has always played softball, then the other parent should say, yep, sounds good. But if they don't communicate back, my clients say, well, what am I supposed to do now? So you may want to have an order that describes, you know, if one parent asks for an activity, how long does the other person have to respond before you just go ahead and register kids in an activity? The court can consider the use of drugs and alcohol in the presence of the children. The court can also consider the custodial interference of the other parent or unwillingness to foster a positive relationship. Courts will almost always include in a custody order, no parent shall disparage or otherwise cause a loss of affection towards the other parent. Those are very difficult cases to prove because oftentimes it would mean the child having to say, my parent one called my parent two a jerk and an idiot and said that I didn't have to listen to them. It's very difficult to prove because courts don't want to have kids coming in to testify. So certainly that is something, but if you can show the in text messages or other communications, how one parent is obstructing or interfering with that relationship, just, you know, Perhaps they're not allowing phone calls. That could be one way of showing the interference. How am I doing on time? Not good. I even set a timer on my phone, but it's not very helpful. Okay. Whew. What is the court's response? Domestic violence as a factor. Family court ordered sole legal custody as the parents here were unable to effectively communicate. Here, the father perpetrated escalating acts of physical violence, and any attempts to communicate deteriorated into arguments. I'm not going to talk much about that since I don't have that much time. That site is there. But again, getting sole legal custody can be very difficult to do, but the more that you can show of that, that factor, that can be a helpful thing. And also if there is a stay away order of protection that says refrain from communication, if it's a criminal court order of protection, I always argue, how can parties have joint legal custody, which implies the ability to communicate, when there is an order that says don't communicate? So that usually is a very persuasive way of getting sole legal custody. I have not talked at all about the child support. Should I just shift to that? All right. So I'm gonna skip ahead. I apologize that I talk a lot, but I'm gonna leave you with those materials with regards to the custody, perhaps using the rest of my time to talk a little bit about the child support piece. Here we go. The court shall issue an order of child support. Important to file a petition sooner rather than later. You can only get retroactive child support from the date in which you actually file your child support petition. There is a new development in 2021 that the Family Court Act and under the Domestic Relations Law added a provision authorizing that a parent can now petition for child support of a disabled adult dependent until they reach the age of 26. There are specific things. You can't just say that my child is disabled. There are specific things that you must allege and assert in terms of medical, a medical opinion. You should also, however, be mindful. How would an award of child support for a child over the age of 21, under 26, impact their ability to receive Social Security disability? The child support could be considered a resource, could minimize their ability to get Social Security disability, could impact their Medicaid in terms of the financial qualifications, which could impact the ability for that adult child to enroll in a day program or other services. So you really want to think about the whole before you just go ahead and file that petition. Oh, Joanna very nicely provided the standard for the disabled dependent. Adult dependent is under the age of 26, resides primarily with one parent, and is principally dependent on that parent for maintenance. Adult dependent is developmentally disabled as defined under subdivision 22 of section 1.03 of the Mental Hygiene Law. Child support, missed that sign. Mental hygiene law, developmental disability means a disability of a person which is attributable to intellectual disability, cerebral palsy, epilepsy, neurological impairment, familial. I cannot say that word. Just, do you have, how do you say that, Joe? Familial. Okay. In the brevity of time, this is the standard that I was saying that you have to allege in a petition in order to have the court consider whether a child support order to age 26 is appropriate. So it's important that your petition be very specific and not just say, my adult child is disabled, period, the end. You won't get very far. How is child support calculated? The legislature has I'm missing my pages. Sorry. Food for thought. Possible impact of financial eligibility for Medicaid, Social Security benefits, temporary assistance, and that you may want to guide clients to discuss with an estate planning attorney, Social Security attorney to discuss the impacts. So that's what I was talking about a few minutes ago with regards to that piece. How is child support calculated? The legislature has provided a formula 17, 25, 29, 31%. And then 35 of the combined parental income for 5 or more children. Important at the first court date, if you want to have a temporary order to provide the court with as much information, W-2s or recent pay stubs. Mandatory add-ons, one of them is a daycare cost. If a custodial parent has daycare, you want, and especially if it's attributable to employment or the course of finding employment, or as part of a educational, if a parent is going back to school to obtain a degree, the court can issue an award with regards to the daycare costs and how those would be shared, typically in proportion to income. Health insurance, get from your client the breakdown of the health insurance attributable to the children. Family minus individual equals cost attributable to the children and how that cost should be shared. I see you looking at me. Okay. Oh. Do you want me to keep going? What do you want me to, just tell me. Okay, yep. Yes, okay. I think I'm gonna wrap up with some of the practice tips, making sure that your client's financial disclosure affidavit, it tends to be a 2-page document that they fill out with their income and expenses, providing to the court tax returns, pay stubs, if the parties are still married, obtaining the tax records from the IRS, subpoena bank records, employment records, business records. These are especially important if the person who you want to pay support is self-employed. You want to compare how do they put money into their bank account? How do they spend money? If they say, I only earn $20,000 from my business, but you can see $100,000 a year going out, that doesn't make sense. You can't spend money that you don't have. So trying to establish other ways of showing income by way of spending. Property records to establish ownership, imputing income. I can quit my job today. I could say tomorrow I have 0 income, but it doesn't mean that I am unable to earn. That's the idea of imputed income. An easy way of also showing this is getting the Social Security Administration lifetime earnings statements. You can show the history that someone had earned in years before. That's a really easy, helpful way of establishing prior income if a person says, I'm now not working. So, and just be prepared. I'm sorry that this is rushed, that I rushed through some of the slides. Joanna did a super great job with the presentation material. So I want to thank Joanna. I want to thank Nick and everybody at Legal Aid for this wonderful program, and please support Legal Aid. Thank you. Okay.
I'm so proud to get to work alongside our amazing attorneys and our board of directors members. We really appreciate all your hard work and your contributions to the field and the practice. And I could listen to you two like all day. So, maybe a future program. Thank you all. Thank you. So we do not have a lot of time in between sessions. We really backed these in to pack in as many CLE as possible. There is coffee service and snacks just out here in the hallway. Please help yourselves as we set up and get going with the next program. Next up is civil evidence updates with Professor Mike Hutter from Albany Law School. And also, all of these materials, including the slides, are available in the content that we emailed to registrants. If you have any difficulties opening the zip files or you need them sent to you again, please let our registration desk know so that we can make sure you have all the material to look back at, because as you can see, there's so much fantastic content here. Thank you very much. And Mike, let me just set up your pieces. I will hand this over. You know where the clicker is, right? Okay.
I'm fine. Good morning. My materials now, my discussion will be talking about developments and evidence over the last year, last judicial year, September 2020 through 2023 of August. And what I'm trying to do with the materials you have is collecting the cases that add something to our evidence developments, new developments, or just refinements, or just simply some friendly reminders. And I try to gear it to the materials that will be very important for your work. So I obviously omitted a lot of things with respect to personal injury lawyers, automobile accidents, stuff like that. I didn't think you want to hear anything regarding that. But last year, there were some significant developments. But what I want to start out with is on the beginning of my materials. I'm not sure how many of you are aware of, but you got to be aware of the New York Evidence Guide. You've probably been using for years Richardson, maybe Martin Capra as your go-to evidence source. The Richardson book is hopelessly out of date. Dick Farrell, the editor, has passed away, and it's now about 20 years out of date. It's great for historical, but nothing new. And the other major treatise, Martin Capra, it's just starting to be revised, but it's pretty pricey, $700 for the text. And even it's not online. To get online, you have to pay additional money. So several years ago, 2017, then Chief Judge DiFiore thought that it was going to be necessary to have a codification of New York evidence law to keep it current, recognizing that the legislature is never going to enact a code of evidence. Chief thought it'd be best now to have a compilation. He appointed a committee chaired by Bill Donino, a very well-regarded criminal court judge, and then retired Court of Appeals Judge Susan Reed. And I was appointed reporter to that committee. We now have completed our work, and we're updating it constantly. And if it's online, it's available for everyone, not just judges. Chief Judge DiFiore made it clear that you want to make it available to the bar. So the bar and the court has a common source to go to. And what we've done now through 12 articles, similar to the organization of the federal rules, but now obviously containing New York cases. We have endeavored to put in there any New York Court of Appeals case that holds something, to compile all those rules, and together with the statutory codification, the statutory materials in Article 45. And then we've been adding on some material with respect to the appellate divisions. Again, it is not an academic exercise what evidence law should be. It is what evidence law is. And the good news is that the appellate divisions now are citing it, constantly citing it, which means that we're now recognizing that it's pretty authoritative, but it's really your go-to book. And I know what a lot of practitioners do. They get on the website, they put it up on the screen, print it out, put it in a loose leaf binder, and they put it right next to their CPLR book. But it's a very important now development in evidence law. And again, it's being updated constantly. And we're looking to move now maybe towards putting out on the website of the Unified Court System a monthly update of cases now that come down, whether it's family court, criminal court, civil court, not just trying to be a criminal court material. But I would really urge you to take a look at that, even if you want to do it during my presentation, just to get an idea how important that guide is. Now, with the time limited to me, obviously I can't cover all the material. The material is designed to be an update to supplement now the evidence guide with more cases, appellate division level. And the material there, that's what it is. Now, obviously, I'm going to be picking and choosing some cases from there. And since I inevitably run out of time, I'm going to do reverse order. I'm going to start from the end. Because first of all, it's the non-testimonial proof, looking at social media, the developments on getting in evidence that are in digital form. And I'll start in that respect on you flip to page 70. Oops. Page 65, where there's some very good, interesting cases now starting to flesh out New York law with respect to digital evidence, whether it's a text message, email, a post on a website. And in that regard, the good news is that we're using, in this era of digital evidence, the old rules and just putting them into a new medium. And again, obviously, when the rules of evidence develop, there's no such thing as the internet, no such thing as text and emails. And I think back when I was growing up, the big thing was Dick Tracy's two-way radio, handheld radio, wristwatch, which we thought, oh, that's ridiculous. And even as late as 1995, a well-regarded federal judge, when presented with evidence that was offered in electronic format, email, said, not in my courtroom, not this voodoo evidence, never, ever. And now he's eating crow. So digital evidence now has taken over. And we're slowly developing a pocket now of evidence directly related to electronic. And the first one I want to mention, a very important decision by the Court of Appeals on page 65, the People v. Rodriguez case. And it comes up in the context now of introducing in a criminal case text messages, especially now when the phone that was received the text message has now been destroyed or lost. How do you get in text messages? Now, keep in mind that with text messages, unlike emails, the server does not preserve those text messages. They're only preserved on the phone. And you can never then get those text messages into evidence unless you now have other means. And that's what happened now in Rodriguez, a sexual abuse prosecution against a high school coach, alleging to have an illicit affair now with a 15-year-old girl. And how does that come about? Well, the boyfriend of the girl now is at home with her, and her phone beeps. And she immediately, of course, opens up, see what's going on. And he's curious, and she's reading it, smiling. So he grabs the phone from her. And on there's a very sexually explicit from the coach. So he's looking at this, and then he's scrolling down, because remember, all those messages keep on scrolling. And this is going back about 6 months, and it was getting worse and worse. So he asked her, what's going on? And she now tries to grab the phone. He then whips out his iPhone and takes snap screenshots. He now photographs all of the text messages going back at least 4 or 5 months and presents them to the district attorney as evidence now of what's going on. Now, in the meantime, the girlfriend is now very upset and destroys the phone or loses it. We don't know what happened. So at the trial, the key evidence now about this is going to be these text messages. How does he get it in, the prosecutor? How does she now establish admissibility? Now, clearly it's hearsay, but it's an admission. The point now is, and this is the real key now with authentication. Authentication now of email, because of the possibility of hacking and fakes. Court of Appeals, in a very important decision, a unanimous decision, which is unusual for that court. So I like to see when I'm speaking with one voice, now says through then acting Chief Judge Canataro, screenshots are nothing more than a photograph. Just because, again, it's an electronic form, pictures of that, makes it no different from a regular photograph. And it's the usual is established now, the fair and accurate representation is to depict what it says. So that he's looking at these screenshots and so authenticate. How do they do that? The boyfriend now testifies. Yep, that's the picture I took. That's enough. And those photographs now come in. Now you might think, well, gee, do you have to authenticate anything else? No, nothing. So long as you have the recipient or now someone who viewed it, maybe you might call him an eavesdropper, but he can now look at those and now testify. And then finally the girlfriend comes around and she now admits receiving all them. But what's significant is that the court had the opportunity now, remember the best evidence rule. It goes companion with authentication, that you have to produce the original or explain why you don't have the original. Well, what's the original now of electronic evidence? The original is really the hard drive. So the court now had the opportunity to now do what the feds have been doing in that, well, when we're dealing with digital evidence, a printout or hard copy or oral evidence, would be sufficient to satisfy the best evidence rule. Obviously, we don't want to be pulling in the hard drives. The court now heard oral argument on that point. It was thoroughly brief, but the court simply said, we address we review the other claims and we affirm and reject them. So what it indicated here is, at least implicitly, that with electronic evidence and screenshots, you have no real problems in getting them in, so long as one person can authenticate. Now, if you jump to page 72, two more recent decisions on that same point about authenticating text messages. And again, my understanding is, at least from reading some blogs, and that people now are sending more text messages than they are doing emails. Emails are kind of passe. It's either Instagram or text messages. So you see on social media, DT versus CT. How do you authenticate the message? Again, the best way is the person who received them. It's just simply following along what Rodriguez says. And then even the more recent one for the Fourth Department, the People versus McKay, that same point. And what's interesting about the Fourth Department decision is a little bit more instructive when we're dealing with non-testimonial proof. And this carries over to emails. How do you authenticate them? Well, the old traditional rules. You look at the contents. Do the contents suggest who the author was? Is the material in there something that only the sender would know? Basic common sense. And what's the main point that the New York courts have made, you do not have to establish through some very strong showing beyond a shadow of a doubt. He's the sender. She's the one who wrote that. It's more simply common sense preponderance. So it's an interesting way that the courts are going in that regard. And a lot of those cases, again, no real email cases from last year, but they certainly are applying the same principles. Now, next time, again, moving backwards, starting on page 52, privilege. And I want to add something that, not in my material, but the very fine presentation you just heard, that will supplement that on the attorney-client. But a couple of things with privilege and the attorney-client as it impacts your practice in dealing with that. The Rue case, down at the bottom. Keep in mind that the attorney-client privilege covers confidential communication concerning legal matters. If it's personal matters between the attorney and the client, business, personal, stuff like that, not protected by the privilege. Well, sometimes you're going to have a mixture. You'll have some legal stuff in there, and then you'll have some non-legal stuff. Do you lose protection when you have a mixture? And the Theroux case, again, restating law, says no. We're looking at predominant. Just because there may be some mention in the email between the attorney and the client that there's something personal going on. But what are you gonna do tonight? Did you see that show? That's not going to defeat, so long as its key will be there is something in there about legal matters which predominates. Now that becomes very important in the sense that you'll certainly have communications back and forth with the client. What should I do? What's my next step? How should I be protecting myself? Is that now going to be personal or is that going to be legal? I think in many respects in a domestic violence situation, that's going to be legal advice. And again, in that regard, keep in mind your responses that you always want to trigger and make sure that when there's a subpoena out there, a request for the communication, that you can point to that there are some legal matters in there. Now, the one case I want to mention, it's not in here because it came down in 2021, but it was alluded to, at least the area, by our previous speakers. Sending emails or text, let's say sending emails. Your client now is employed by the state, maybe in private practice, in private employment, and they now are communicating with you regarding this support matter, this divorce matter, whatever it is, this eviction matter. And they're using the employer's computer, sending it to you, and you're having a confidential, what you think is a confidential communication. Well, the appellate division now, 2 years ago, in a very important decision, and I don't have the site, I'll get it for you at the break, but it's the Marvel Entertainment case, in which the appellate division now said that that communication, when you're using your employer's computer, not your own laptop, but you're sending it under your email given to you by your employer, that is not protected by the privilege. That is not protected by the privilege. Why? Because the employer has the right to access that information, those emails. And normally that comes from the employee manual, which will say anything, we can now review your emails. That's done now to make sure there's no sexual harassment going on and other stuff. But most people don't realize that when they are texting or emailing their lawyer from their office, they think it's attorney-client privilege. It's not. And the case that the Marvel Entertainment cited was a case years ago down from New York City, where a doctor who's on staff at NYU Mangione, clearly he thinks he's now going to be dismissed. And he's trying now to protect himself and trying to keep a record of what they're doing, what I've been doing, and some of the things that, yeah, maybe I shouldn't have done. Sending that to the attorney. And all that turned up against him when he sued now for wrongful termination. So be careful about that. And I think here what you should be doing is making sure that if your client needs to communicate with you during the day, that they should maybe think about using their own laptop and maybe even now getting on the employer's server, but using their own private email. This is a real chance now that they're going to blow the privilege because of their use of their employer's material, the employer's computer, which has been supplied to them. Now, the other case that's important for you and the attorney-client, the Homoport decision on page 53. Confidential communication, third party presence defeats the privilege. But what if that third party now is necessary? It's going to be helpful that the elderly client, the feeble client, is really unsure and really wants a loved one to be present, to be there. This is the companion. That presence, according to the Homoport case, does not defeat the privilege. It's third parties who have nothing to do with the material. It's just, can I bring in my best friend? That will clearly defeat the privilege. But again, if the person is necessary, Homoport is recognized and does not defeat the privilege. Now here it was interestingly, the one person brings in basically a stenographer to take notes of the communications between the client and the attorney. And why? Because the client wanted to make sure that I'm spending my thoughts now, instead of writing it down, what he's saying, what's transpiring. Rather, that what they're doing here is that I want to have now a person to take the notes to help me to refresh my recollection later on to memorialize. And the first department said that's okay as well. Now, one last attorney-client privilege case on page 54. The Empire chapter, and involves a lot of times, and I've seen legal aid going after related public interest firms using FOIL to get information that will be helpful in their litigation or in their broader plans for making challenges to certain state programs. And FOIL now, keep in mind, it does of course have that attorney-client exemption that the agency does not have to turn over attorney-client material. Now, certainly the government attorneys have enjoyed the protection of the attorney-client privilege. That's been well settled here in New York for many years. But the key is, and what the third department does, and a very thoughtful decision by the third, is now make sure that when those communications are being sought, is that they are really directed to legal matters. That's what's going to bring in the protection of the privilege. So here, the Empire Chapter builders wanted to see a report that now they believe would help them in litigation because they didn't get a contract. So they put out the request is denied, and the third department says no. What you were seeking here and what was done, the communications involved, not legal matters involving Department of Transportation, legality, but all sorts of other things. And the other things now defeated the privilege. So when you think about FOIL, You might think, oh, I'll never be able to get it. Hey, if there's some stuff in there, it's not legal, you're going to get it. Okay, moving backwards again. Couple of things now with your favorite topic from law school, hearsay. And few things now that I think are very important with what's going on with respect to your work. And I'll start now with an exception on page 27, the adoptive admission. Now, it's a 2017 decision, but I'd like to put in these old cases to see how they are faring subsequent to their handing down. And People v. Vining is an excellent decision authored by then Court of Appeals Judge Leslie Stein. And it involves a very dangerous exception and something you've got to be aware of. And you may not think, see, that can't be. What happened in this case, domestic violence. The battered spouse finally says, I had it with you, calls 911. 911 comes with the NYPD. He's arrested, sent to Rikers. And the next day, she gets a phone call from him. Will you visit me? So she says, okay. So she gets there. Now, on the Rikers, and it all says, all conversations are recorded. Except, of course, attorney-client. So the first thing, she sits down and she says, why did you do this to me? I've suffered 3 broken ribs. Look at my face. I'm a mess. You brutalized me. Why? And what does he say? Basically, how'd the Mets do last night? Did not deny it. Did not deny it. So she then goes forward with the criminal prosecution. And the key evidence now is, again, is conduct. Now, the accusation, the out-of-court statement is, you beat the hell out of me. Now, that's not an admission because it was not made by the defendant. But what Judge Stein points out, that there is a not a frequently invoked exception prior to then, the adoptive admission. When accusations are made in your presence and you don't deny them, and you don't deny them in circumstances where the reasonable person would deny them if it weren't true, you've adopted them. You've adopted them. Other words, speak up. If someone falsely accuses you of something, say, I didn't do that. But since he said nothing, but did not deny it, he went off on a tangent. And Judge Stein even pointed out, even silence, nothing, can be adoptive admission. Now, she recognizes that this can be very dangerous. Because maybe people may not realize that. But now that's the law. And the key point now, and Vining really deserves a good reading, and especially in light of the dissenting opinion by Justice Judge Rivera, that you read them together. So main points are made, which then was made clear last year by the Noel decision on page 27. The adoptive exception comes into play when it's clear that the defendant now heard it. If there's no proof, no foundation that they couldn't have heard it, then it doesn't apply. And sometimes there may be some issues here about, did you really hear it? But again, what Judge Stein pointed out in Vining, that he clearly heard it. It was right there. It was a one-on-one conversation. So be aware of that exception. The other development with respect to hearsay is with respect to now business records and foundations. And especially now when you're dealing maybe with mortgage foreclosures, defending, may have eviction proceedings, who's the real lessor when there's been a couple of assignments of ownership, repurchases. The courts now are really cracking down with respect to laying the foundation. So for example, the third department decision on Velocity Industries on page 31. Again, the court makes a very good point here now. And you might think there's the mortgage was made, is then sold to a factor firm. And they now are the ones that bringing the foreclosure action. And all the initial materials, the mortgage, failure to pay, everything else is basically the records of the original mortgage originator, the bank. But again, they has to be shown. So what's been happening is that these mortgage foreclosure cases, they get very sloppy. They just simply bring in someone, well, that's the records we have. But they bring in no one to now lay the foundation as how the original records were made. The mortgage, authenticate them. Where's the proof now that you didn't pay? And if you don't do that, you might think, well, clearly it's the case. The courts are saying, no, you've got to now bring in that information. Just because now the accounting, the new firm, the purchasing firm can now say, well, here's the records, never paid up. That's not good enough. Lay the foundation for all records. And it's got to be done one of two ways. This is what the Velocity case points out. Now, it's clear the third department is getting a heck of a lot of mortgage foreclosure cases. And they want to make it clear. And they're sending a clear shot over the bow to these companies that bring the mortgage foreclosure actions. Shape up with your proof. And they're telling them what they have to do and what you now should be looking for. Make sure now when they're bringing in the bank records, that if they're not the ones who prepared those records, they now can bring in someone who is familiar with how those records were prepared. Simply because I'm the account manager by the new firm and I see them, I can read them. That's not good enough. Someone who actually prepared those records or was familiar. Classic 4518 foundation. Or, and the other alternative now is that I have those records, I incorporated them. I incorporated them into our set of records. We relied upon them. We were familiar with how those records were made. Barring that, these foreclosure actions are going to be dismissed. And if you put in mortgage foreclosure into the Westlaw or Lexis, you will see so many of these cases, especially downstate, where these mortgage companies now are just so damn sloppy. They think that, oh, these records are easy. No, and that's clearly the law up here. Now, one other thing with respect to business records, and you'll have this a lot now with medical records. Domestic violence situation, where the domestic violence victim taken to the ER, sits down with the triage nurse, what happened? And she now will give this tale of woe. He beat the hell out of me. He did this. He's been doing that. And maybe at this point, she may not want to fully cooperate at trial, or maybe want to supplement that with those statements. Are those statements made in the hospital record regarding her past battering or the present battering by the husband, boyfriend? Are they admissible? Now, the very important decision, and it goes back now to Ortega on page 33 by Chief Judge Lippman. Remember, with hospital records or any medical records, they are admissible, provided you lay the classic foundation, regular practice, regular course. We're all familiar with 4518. But now there's a wrinkle with hospital and medical records. The entry must be germane to treatment, not just anything that the triage nurse wrote down or the attending physician wrote down. It's got to be germane to treatment, meaning the doctor needs to know this in order to treat the patient best. And so issues have come up, and it was clearly rejected in Ortega with domestic violence. Well, does a doctor really need to know who beat her up to treat her properly? All you need to know is that she was traumatized. She was thrown down a flight of steps, hit in the head with a sharp object. That's what the doctor needs to know, the source of trauma. Does it make a difference as to who the abuser was? And Ortega, again, thinking outside the box. Sure, in that regard, to treat the person and the domestic violence victim, you need to see the whole picture, the big picture, the context. And it becomes very important now for the ER physician. And again, Judge Lippman's a lawyer, not a doctor. We're lawyers, we're not doctors. And what the court said here is that it's clear, at least clear to it, even a non-medical person, that you need to know that information, who the assaulter was. And if there were past practices, in order that they can treat her properly and especially set up a plan when she's released. So they look at it very broadly. And so some of the cases from last year on that, I've dealt with now on page 34 with respect to now some admissions that your client may make. Unfortunate that, yeah, I guess I encouraged him to do that. Yeah, he was justified in doing that. And she says that it's reported. Well, is that really germane to treatment? No. But now, certainly the triage nurse could come in and testify. Well, that's what she said. But the triage nurse is not available. Can we use that information to get it in when it's written on the hospital record? Here, the courts are pretty much saying no. That when it's not germane to treatment, even though it's an admission against interest, it should not be admitted. So be careful about that. And I have the cases that go both ways on that. And I've written extensively on it. And I think some of the cases here that go the other way are wrongly decided. But again, it's simply my own view. Moving on again. Couple of things with relevance. And I think there's some important points that were made last year with relevance. This is the material starting on page 10. Now remember, New York evidence law is fairly liberal with relevance, so long as the offered evidence has a tendency, a single tendency, to now establish the point for which you are offering it for. That lets it come in. And the cases that I have here on 10 to 11 point that out. And I don't want to go through them individually. It's something you may want to look at yourself. But page 11, this is now is a very important case from the Second Circuit, which cites now and basically is consistent with New York law. And this was a 2021 decision, but it's generating a lot of interest now in the trial courts. What we call witness accreditation. Here are the facts now. Before I tell you what this rule is, here are the basic facts in Tardiff. Plaintiff now is an Occupy Wall Street protester. And she's arrested with the dragnet that the NYPD puts in, thrown in lockup. And she says, wait a minute, I need my pills. I'm epileptic, I need to take them. And of course they ignore that request and she goes into seizures. She suffers then some severe medical sequelae. So she brings a 1983 action against NYPD in the city. Now, the plaintiff's lawyer was very much concerned now about, well, the jury. They may just think of her, she's just some wingnut. She just will protest anything. Just do it for the money, publicity. She's a faker. So what the lawyer did now is then wanted to present and clear this with the trial court to begin with. Wanted to bring in information. Now, normally you call your witness, state your name for the record, and then you go right into the facts. But what the lawyer did here then is did what I call witness accreditation. Give the jury some reason why they might want to believe this witness, that she's a credible person. Now, remember what happens in any trial. You're putting a witness on, you're asking the jury now to assess credibility for maybe 10 minutes, 20 minutes of conversation. Now, before we make decisions on credibility, but deciding what to do, we'll think it through. Think a little bit more information. So what the lawyer did here is brought out the fact now that the plaintiff, she now was one of the founders of Occupy Wall Street. She had written about corporate greed, corporate wealth, and how they now have been really screwing the little person. And that's why she joined up with Occupy Wall Street. She also had a history now of dealing in other social protests. But again, not just simply as joining, but as a true believer. And so they wanted to put that in and developed it at length. The trial judge said that's fine, overriding the defense counsel's objection. Now, that's the first point. On appeal, that issue came up. And the Second Circuit said that's fine. There's nothing wrong about giving the jury basic background information about your witness, the good stuff. And here, you might sound like character evidence, like Molyneux. And that's, of course, inadmissible. But this is not full Molyneux. This is maybe a quarter Molyneux. And it's relevant It's very relevant. So they cited two cases, and I cite them now on page 12, that from other federal courts, postal worker is charged now with stealing from the mail, and he denies it. And when he testifies in his behalf, the first thing that the lawyer brings out now is his service in the military. 12 years of the Marine Corps. And then when he left, he then went to join the Postal Service and been a postal worker for 20 years. Unblemished record. Admissible? Yes. Why? Witness accreditation. You didn't go too far. And that's what the Second Circuit warned. Some basic information. And so that goes to the second point. The woman also wanted to bring out, the plaintiff, that she now had adopted two disabled, mentally and developmentally disabled children from Peru. And she had devoted a lot of her spare time to working with that community of dealing with children who suffered disabilities, mental or physical, and was helping out tremendously in that area. That the Second Circuit said no. That went a little too far. Now, I think reasonable people can maybe disagree with that. But the point now that Tardif is making is that you now can accredit your witness with something that's looked good to impress the jury or the judge. And I know this is a hot topic. When I spoke recently before a judges group, that they were saying that now in light of Tardif, that they're now seeing a lot of these requests. And they now are saying, within limits. So you might want to think about that point. Now on Molyneux, of course, the infamous Weinstein case, and that's now before the Court of Appeals. And the thing with Molyneux and Weinstein, and when you look at the things that were brought up against him, he's a real dirtbag, without a doubt. But every bit of dirt was brought out. And the argument before the Court of Appeals is you went too far. It'll be interesting to see what the court does with that, especially now with his new composition. Now, related, on page 14, habit evidence, an overlooked rule of New York law, which is now we have a specific rule in the guide, and it's a model of pattern jury instruction. One's regular response to a specific situation that's recurring is admissible to prove that on the day in question, that person now acted in accordance with that habit. He did it before, she did it again, she did it this time, but it's got to be habit. What's habit? The third department in Harmon, developing some prior cases that cites, and it works with the really fine decision by then Judge Mackey, who's now on the third department itself. Comes up in the context now of the Diocese of Albany, where the plaintiff now, to show the pervasive sexual abuse and the diocese did nothing, wanted to establish that the diocese had a habit. When they found out that a priest was abusing kids, they would cover it up. They would not report it. They would not punish the person. They just pretty much say, don't do it again. Maybe they'll put them out in some rural parish, but they did nothing. And is that a habit? Yeah. When you think about habit, you think, well, I always buckle up. What's the first thing you turn to in the newspaper? Stuff like that. Could this be a habit? And the third department says yes, so long as there are sufficient instances. And they're really leaving it with trial as to whether or not they could show this. So in connection with that, the plaintiffs wanted to see the personnel jackets, which would at least show that. So keep in mind now, this comes up a lot now, the regular response. Plaintiffs can use it. Now, defendants can use it as well. And that's the point now of the Baker case from the fourth department. Just came down last July, just over a month or so ago. Did the doctor follow this procedure? And I don't want to get into the specifics, it's not all that necessary. Did the doctor follow this procedure? And he says, I don't recall this patient. But I can tell you, I always do this. Whenever I'm confronted with this situation, I do it. Now, sounds like habit, but the Fourth Department pointed out a clear limit to that. One's regular response to a given situation, which means you control it. That it's a regular response. They present with the same situation. But the Fourth Department points out now in the record, yes, you did this, recommended this procedure, you did it, but it was dependent more times than not on the condition of the plaintiff, the condition of the patient. And sometimes you would vary. And once there's variation, that defeats the habit. Now, page 16, and this is going to be this is an emerging area, and I think it's going to be more important now for you. This is the rule of completeness. And I raise it now because the feds have amended their rule in a large part to conform with New York rules. But here's the situation. I'll use this hypothetical. Your client now says, yes, I kicked down in the custody. I kicked down the door. I destroyed it. And that's the written statement that she gives, or maybe the oral statement. But later on in that written statement, she says, I was trying to rescue my daughter. She was screaming for help. Now, the first part, I kicked down the door, an admission, right? Comes in against her. Now you want to get in the justification. Why? The explanation. But that's not an admission against her. It's her own statement, and that would be considered bolstering and hearsay. Now, with the rule of completeness, you can get that in. And a lot of lawyers and judges are unaware of this. New York's rule of completeness is that when a statement is offered, written or oral, and it omits a part that is necessary to explain, or the absence of which would show the part that comes in is misleading, the trial judge has the discretion to let that part in. So in my hypothetical, the trial judge now could let in that statement. I kicked the door down to protect my daughter. Now it's clearly hearsay, but the rule of completeness now lets it in. Now the problem here is that, yes, it's hearsay, it's admissible. Is it coming in for the truth or for explanation? That's where the action is going to be. I think here it's got to be for the truth. It means it's meaningless unless it comes in for the truth. Otherwise, you have to give that crazy instruction. You may only consider it for purposes of misleading, but ignore the truth. It's ridiculous. But you're going to see this point coming up. And the other thing that trial judges now have the power under New York law, they can now direct that statement, that omitted part, to be admitted right then and there during the other side's presentation, instead of waiting until the direct case of the other side. And New York law has preserved that possibility on a recognition that you wait a long time, the jury's going to hear the really inculpatory material, and later on they now hear about the exculpatory, maybe too late. So trial judges have that discretion. I think certainly when you now invoke it, it has to be done right then and there. And maybe if the court says, well, I don't want to do it on the direct examination of the witness, we'll make sure it's brought up now on the cross-examination, first of all. But watch out for that. That's going to be very important over the next couple of months, next year. Couple of things with impeachment. On page 20, and this is now where I think New York law is starting to move away from the rigidity with what we call the bad acts impeachment. New York law says any bad act that the witness has engaged in, even though it's not the subject of a conviction, if it's bad, quote unquote, it can be used for impeachment. Well, they never really gave a good definition of what was bad. Well, because of the abuse of this and people bringing in everything but the kitchen sink, the peccadillos, like you stole cookies from the cookie jar when you were young. We don't need that crap. So it came to a head now in 2016. Yes, but it's development since then. This is People v. Smith. Very important decision by the court, authored by the late Judge Abdus Salam. Comes up in the context now of a police officer who now is the complaining witness or the chief witness against the defendant. The police officer has a lot of baggage. Several instances of discipline for making arrests without probable cause, engaging in unlawful strip searches, you name it. He was a rogue cop. But he was kept on the force. Can I use that now as impeachment? Is that now considered a bad act? Well, the lower courts, until Smith, said that, well, cops are cops, that's not bad. And Judge Abdus Salam destroys that. And she sets forth now the test that I believe those trial judges are now following. When you're putting in, forget about convictions, uncharged criminal conduct or uncharged conduct. She's looking now for three things. First, good faith. Is there good faith belief that these acts occurred? Not beyond a reasonable doubt, not clear and convincing, not even maybe preponderance. Something in which you now can assert in good faith that this happened. Now, the next decision, the People v. Rouse decision, came down 3 years later, in which the good faith now was a federal judge in a 1983 case now said to this about the cop, "You're a goddamn liar. You're worthless. Look what you've been doing." And that judge, the Court of Appeals said, that's good faith. Well, you don't need that strong. Second, and this is critical, in focusing on this, and this makes a lot of sense, to the extent that you want to accept the old wives' tale, the truism, well, if you've done something bad in the past, if you lied in the past, you're probably lying now. Well, what she does now is formulates a little bit more specific. Let's make sure that the prior act really relates to truthfulness. You may be a drunk driver, you've been pulled over a lot of times for driving while impaired, but is that you're an alcoholic, but does that make you a liar? So what she says at this point, I'm quoting, is that what we look for in this respect now is, does it reflect now on, this is point 2. It's relevant to officer's credibility. It shows an untruthful bent or self-interest. Instead of getting into, well, is it really bad? Is it morally wrong? We have different views on that. But now is a little bit more, maybe perhaps objective. Untruthful bent, lying on the resume, misstating your assets on a loan application, stuff like that. Or self-interest. Yeah, I embezzled this money because I didn't care about it. I was stealing from someone else. I wanted it for my own. You know, a lot of criminal type conduct is engaged in that. That's sole reason. I don't give a damn about anything else. There are no rules. So she's really focusing now on, let's get into stuff that really means something. And the third one is, again, the danger of unfair prejudice, especially when the witness now is one of the parties, how it can be harmful in that respect. There was a very good decision, actually, by Judge Kim O'Connor, Albany Supreme, the acting Supreme, several years ago in a slip and fall case, where the plaintiff now is 25 years old. And 10 years earlier, when he was 16, 15, he pled guilty to child abuse, abusing a young girl, served his time. So in the civil trial, Judge O'Connor was asked to allow cross-examination of the plaintiff by reason of that conviction. Now, and related other acts that were not the subject of the conviction, but he did some bad stuff, let me put it that way. But her point now was, well, wait a minute, in this era, once the jury hears that he was a convicted sex offender, Katie barred the door. There's no way that the jury is going to ever respect his testimony. Too prejudicial. That's the thing now that I see the New York courts anecdotally and some of the decisions are starting to realize. Put some thought into it. And that's the whole point now of Rouse and Smith. And it covers a broad range of material. Now, it's going to be, if you look down at Weinstein on page 22, the flip side, they now wanted to cross-examine if Weinstein took the stand about all of his, quote, prior acts. And I put it here what they allowed. Whether he used a friend's social security number to obtain a passport. Did he encourage people to lie in his favor? Did he tell people to lie to his wife? Did he tell Blackview, an intelligence firm, to manipulate and go after the witnesses who are going to testify against me? The list went on and on. Basically, it looked like they had any bad thing that he did was going to come in. That too is before the Court of Appeals. Should there have been some sort of limit placed on that? So that's going to be an interesting case to follow. I think it'll probably be argued in January. You'll have a decision by February. Okay, it's a couple of minutes left for me. Let me just talk about one other point that I think is interesting. I did the relevance. Let me just go back to page 1, the basic court control. What do you do now when judges go wild? I.e., the judge takes over the examination of your witnesses and does it in a way that looks like that they're clearly have prejudged your case and they don't like it. And they're doing the job that the prosecutor or the other side's counsel failed to do based upon the judge's perception of justice. This goes back for many years. And those of you old enough, you may remember Judge John Klein here in Albany County Court, who's notorious for that and got kicked around, reversed a fair amount of time by the third department. But what I point out now, and this is the Pulliam decision on the top of page 2, and then in the Zhu decision. First of all, if you think the judge is now going too far, make sure you make an objection. That preserves the error as a matter of law before the appellate division. If you don't make the objection, the third department or the appellate division can review it in the interest of justice. And who knows what they'll do with that. Always preserve. Now, again, I think it's very difficult when a judge now is is doing a terrible job. And you now want to say, Judge, you're doing a terrible job. Remember, like Paul Newman in the verdict. The judge isn't going to like that, but you got to do it. You've got to do it. And the question then comes up, how far should courts interfere? How far should they interfere? And again, I think a lot of judges just don't realize what they're doing. You know, snap to bring them back to reality. And the third department in that respect on page 4 had a very interesting decision in People v. Nellis. The decision was written by Judge Ceresia. Before he went to the third, he was a well-regarded criminal court judge in Rensselaer County. He knows criminal law. And what happened in this murder case is that the prosecutor basically ignored every possible rule with respect to Molyneux. And defense counsel just did nothing. Okay. Of course, he's convicted. And the third department now reverses in the interest of justice. That what the prosecutor did was terrible. But the court also did a spanking, I think, of the trial judge. That, wait a minute, you knew this was wrong. You can object. Now, of course, the argument there is that, well, I'm not going to interfere because maybe they're trying to get the door open. But the Judge Ceresia pointed out there's nothing to be gained by allowing this evidence to come in. So he lays down the gauntlet and says, when trial judges now see something really bad going on, and don't be surprised to see this, that they now said, approach. Do you know what the hell you're doing? Trying to making sure that maybe the lawyer didn't know it. If they did it, if they do so, what's the advantage? Have you talked with your client? Are you waiving? But this now is, I think, the way to go. But otherwise, I think judges have a very tough time when they see a case being lost, which could be won when the lawyers don't know what the hell they're doing. And the third department now is recognizing the plight, but says at a certain point, there are minimum levels of evidence that you have to know. Okay, my time is up. Thank you for your attention.
Where'd Joanna go? Joanna, I have a gift for you and Kate also. I just also know where you work, so I forgot. I'm not gonna lie. Thank you so much. And next up is Robert Romaker. Fun story. So he's a managing attorney at LASNNY and was my supervisor like 11 years ago when I clerked at LASNNY as one of my first jobs as a law student and law clerk. And I love that I get to work with Bob now as a colleague. He's right downstairs. We don't see each other enough, but we will. And I'm very happy that he was able to join us here today. One of the best things about getting to plan CLE is that I get to nerd out all day. So I love housing. Housing's near and dear to me. And I really appreciate our in-house experts coming and doing these presentations. So it's just, that's it. But if you move the mouse around, it will show up on the screen. So just, it's like a cat laser. Anyway, it's just here. Yep. Okay. All right. A little taller.
Yeah, I think that works. You guys hear me? So I'm just going to say up front that I've got way too much material for the time that I have. So there's, I do not expect to get through all of it. I'll try to skip forward like they did earlier. If I start running out of time, actually, let me put my watch here so I can see what time it is. Okay. And thank you, Nick, for that introduction. It's been full circle to have Nick as my law clerk and now as our executive director. It's a very interesting thing. So this presentation is going to basically, I'm going to talk about landlord-tenant relationships from the beginning all the way through court proceedings and trials and negotiating settlements at the end. Like I said, I'd love to get through all this, but I think it's going to be a challenge. So the core relationship or the core principle behind landlord-tenant relationships is basically that the owner of the property, the landlord, divests their possessory rights to the tenant. And sometimes that can become an issue because landlords will claim that this is my property, I can do whatever I want. But when there's a rental agreement and you've divested possessory interest to the tenant, that's not necessarily true. A tenant is basically someone who has exclusive use to occupy a rental premises because of a lease agreement or as a statutory tenant under certain laws that don't necessarily apply up here. It can also include somebody who has stayed in a hotel for more than 30 days. And you know, when I first came here, I practiced in Ohio for a bunch of years and I came here and I heard this 30 days thing and it sounded like street law to me. And I'm like, is that really the case? And it really is the case. So that's one of, if you've got somebody who's not in a, kind of what I guess the traditional, renting an apartment from a landlord, the duration of their stay there is pretty important, especially when it usually comes up like in the context of people staying at hotels. How do you form a tenancy? Everybody in here has probably rented at some point in their life, so you probably know this, but it's easy. Either there's a written lease or there's a verbal agreement. Usually verbal month-to-month tenancy because they've decided that they're going to, the tenant's going to rent for a certain amount of money and they're going to have the right to have use of the premises under that rental agreement. I think the majority of them are probably verbal agreements month to month. I think we usually like it when there's written leases just because the terms of the agreement are set out in writing and people signed off on it. and there's not any ambiguity. When you have, when it's just by word of mouth or by discussion, I mean, there's disagreement about what the actual terms of the rental agreement are. And then, this has this case here about, if you're housed by DSS at a motel, again, it's the 30 days and you can be a tenant. The leases are usually 1 year. Of course, you can have written month-to-month agreements. You can have 6-month leases. You can have leases really for any term, but as far as written leases go, 1 year is pretty much the norm. There are other types of housing relationships. These cases can become interesting. The notices are different. And a licensee is basically somebody, the way that I put it here, this is like the legal term. The way that I put usually a licensee is somebody who was given permission to stay someplace and that permission has now been revoked. There's no rental agreement. I mean, it can be somebody like, someone was staying with an elderly relative and then the elderly relative dies. And what's the status of the person who's still staying there? They didn't really reach a rental agreement with the landlord. They're probably a licensee. A squatter is differentiated from a licensee by there's somebody who never had permission to be there in the first place. And this squatter word is thrown around by like municipalities and landlords, and probably about 90% of the time it doesn't apply. But I guess it makes the person who's living there sound bad to call them a squatter or something. I guess it's a dirty word or something. These are all under 713 as far as the notice that's required, and 10-day notices are required for licensee and squatters. Interestingly, if you're an employee and you're renting a residence as part of your employment, as soon as the employment's terminated, the right to housing is also ended, and you don't have to really give any notice. You can go straight to court. Hesitate to say that out loud because I don't know that a lot of people know that. But just an interesting side note is that a lot of times we see the people who are in these kind of arrangements and they don't get paid. They get, instead of getting their $700 a month that they earn, the landlord just applies it toward their rent, which is, last I knew, I think that violates the Department of Labor regulation, and you probably could file a complaint because you're working and you're not getting paid wages. So just an interesting side note. I guess I can't blame anybody for this small font since I'm the one who did these slides. So basically, evictions are summary proceedings. The cornerstone of them is, oftentimes 90% of them are non-payment of rent cases. The whole process is set up for a landlord to get in quickly, get the tenant out because they're not paying, and get somebody in hopefully who will pay. And basically, that's what we're fighting against. That's kind of the train that's going flying down the tracks. And then, as a representative of a tenant, you have to kind of get there and try to stop it and push it back. And it's a speedy train a lot of the times. It's also considered to be a special proceeding because, it's not like a plenary action or just a normal civil action that goes months and months and months. These things go fast. Not as fast as they used to, thanks to the legislature, but still fast. You have a right to a jury trial. People don't usually exercise that. The beginning of a summary proceeding is started by a notice of petition and a petition. Notice of petition is really just like a summons in any other case. It basically, when you get served with it, it tells you that the eviction action has been filed against you. There's a hearing. Here's where it is. Here's when it is, and here's some of your rights with respect to the process. It has to be a summary proceeding has to be for the recovery of possession of real property. If you start getting into things like title to the property or land disputes and things like that, they are not right for a summary proceeding. Summary proceedings can be brought in Supreme Court, though I don't think that I've ever seen that happen here. More commonly, they're brought in city courts or in local justice courts or justice town or village courts. The two type of proceedings that you have generally are non-payment proceeding, which I said is like 90% of the evictions that we see. That might be, I don't know, maybe that's a little bit high, but most of them are non-payments. There are also holdovers. So in the non-payments, the law was changed in 2019, which seems like that's like 4 years ago, but with a pandemic in there and the courts, 4 years ago is only like a year or two ago. So there's not as many cases under this new law as you might hope or expect. But now rent is defined as rent. It used to be that you could designate all these different kind of charges as added rent, which I think most of us thought was just some bogus thing some landlord's attorney came up with, or conservative legislator came up with at some point. So now it's rent and only rent, and you're not really supposed to even seek fees, charges, or penalties, because you see late fees, attorney's fees, fees for serving the predicate notice, fees for serving the court papers. It's just like, I always think it was like a loaded baked potato in a bad way. You've got like the chives and the bacon and the cheese and the sour cream. They load it all up. They're not supposed to do that. We're still seeing it. There's one lawyer that I won't name around here who represents a lot of landlords and who does that loading up. He's got the best baked potatoes, I tell you, in the whole Capital District. And so, we are actively actually fighting against that. I know in one case that I'm directly involved in right now. So it's just supposed to be rent. It's supposed to be just for the amount that you're paying to use and occupy the dwelling, and that's it. It's a little bit confusing, and we found with respect to attorney's fees, because there's another statute, RPL 234, that was changed along with the new law that says you can't get attorney's fees on default, but it implies that you can get attorney's fees otherwise, which seems to conflict with the new RPAPL 702. So that's something, actually, I think we're going to be litigating in a couple of weeks. A holdover proceeding basically can only be brought when a tenant holds over. There's some termination notice, and once that date comes, if they don't leave, they're holding over, and so it's a holdover petition that ensues. There are two types of holdovers. Basically, there's a no cause holdover. That's when you just give a like a notice to say we want to terminate your lease, we don't rent to you anymore, or a lease expires. For cause holdovers are when there's an allegation that somebody breaches their lease, and that the lease allows a breach of that provision for the landlord to terminate the lease agreement. I think I went back a slide. This thing's a little sensitive. And something I'll say about the holdovers before we go dive into non-payments. We have seen situations where landlords, attorneys who aren't communicating with their clients or paying attention will bring holdover actions to try to just give, like a termination notice right in the middle of a lease agreement. And there's no cause alleged. It's just, we're treating it like a month-to-month tenancy. And then, as a tenant's lawyer, like, is there a lease? And there's like, yeah. And then you see the lease doesn't expire for 5 or 6 months. And it seems totally like counterintuitive, or who would do that? But we've seen it a lot. Seems to happen. We've seen that a lot in Schenectady, maybe not in the recent past, but over time. So in any event, non-payment proceedings, the landlord now has to give a notice after the rent is 5 days late by certified mail that just says the rent's late. By the way, you didn't pay your July rent. Please pay it, or I'm going to have to take further action. And it has to be sent by certified mail. This one is forgotten a lot, I suppose partly because it's new. And I'm glad that it's there. It's an additional protection. I could see an argument being made that, it's kind of silly to do it because who doesn't know that they didn't pay their rent? But it's there, and I don't know. I think it's an affirmative defense. I don't know that it's a basis for moving to dismiss out of the gate. The rent demand, on the other hand, is different. It used to be 3 days that the rent demand would have to last, like when there's a non-payment. Now it's 14 days, which, provides the tenant more time to kind of figure out if they're going to be able to scrape the money together to pay what's due or to move. So that obviously is a welcome change for us. It has to be served in accordance with RPAPL 735, which is basically the one that sets out personal service and substitute service. I'll be talking about that, time permitting, here in a little bit. The interesting thing that we've come up with is, as applied to the rent demand, it kind of doesn't make any sense, because when a petition, a notice of petition, or a predicate notice is served not in person, by substitute service because they gave it to another adult there, another person of suitable age and discretion there, or they posted it on the door and then they mailed it, service isn't effective until the affidavit of service is filed. It's a question that's come up because we've seen that as a defense, but then we wonder, how do you file an affidavit of service for a rent demand when there's no proceeding pending? So it's like an argument that we've seen that's there, but it's a little puzzling as to how to actually make it work practically. There are all these requirements about the rent demand. It has to give actual notice. It has to tell the tenant how much is allegedly due. It has to break it down by month. It has to be clear and unequivocal that you either have to pay or you have to move. And if you don't, we're going to pursue legal action against you. And so this is jurisdictional, and we were able to get some cases dismissed because of a failure to comply with these requirements. Obviously depending on who the court is and what the situation is. And as far as that goes, any of these predicate notices, we're talking about a 14-day rent demand now, for a no cause holdover, it's a 30/60/90 day notice. All those notices have to expire before a petition can be filed with the court. If it's filed before the expiration, it's a premature filing. Court lacks jurisdiction, it's a basis for dismissal. Holdovers, I feel like we've already kind of talked about this a little bit. They can, can be when the lease terminates, when there's some sort of a notice that's given because it's a month-to-month tenancy, or when, again, there's a breach of the lease that's alleged, and there's a notice that's given in compliance with the lease to terminate it because of that breach. And again, the tenant has to stay there past the expiration of the either the lease or the predicate notice for them to be considered to be holding over. And predicate notices for holdover proceedings, the landlord has to serve a notice before they can bring a holdover proceeding in almost every instance. I guess the employment example that I talked about earlier under 713 is one where there isn't a predicate notice isn't required. Oftentimes it's good to obtain the lease if there's a written lease and determine if there's additional notices that are required by the lease that aren't required by the law. Sometimes they have notices to cure. One thing that we see a lot is that there's provisions in some of these old pre-printed leases that say if there's a alleged violation of the lease for these things, and almost non-payment's almost always in there, you have to give a 5-day notice. And then if they don't cure it, then you have to give them a 3-day notice. And I don't know, most of the time we see these leases, they don't comply with that. I assume the argument is, well, we gave them 14, that's more than 5 or 3. But when the lease contemplates 2 notices and it's a cure period and it's sequential, it would seem that the case should be dismissed if the landlord can't even follow their own lease. And I always think those arguments are great because some judges and justices that you go in front of don't know the law in this area, or may know the law but don't really want to follow it if it leads to an outcome that they're not big on. So when you can argue to any judge, listen, they didn't follow their own lease. They wrote it. Everybody knows landlord write leases, tenants don't write leases, and they can't even follow it. All I did was read it, and there it is. And it seems like it should be a really good argument. Again, depends on who you're arguing in front of. And again, the notices have to expire before the proceeding can be commenced in court. The lease can add to what the law requires, but not subtract from it. So I suppose they would have to give one with the 5-3 in the lease, they'd have to give a 14-day rent demand to comply with the law, and give a 5-day notice to cure, and then a 3-day that they didn't. It's a lot of notice, but you probably should read your lease before you have your tenant sign it, I guess, if you don't want that provision in there. But if it's there, it would seem that everybody should have to comply with it. Termination actually terminates the tenancy and tells the tenant of the termination, as well as if you don't vacate by that termination date, then we're going to bring a summary proceeding against you to evict you. Now, it used to be that in month-to-month tenancies, the tenant or the landlord would just have to give 1 month's notice. It was 30 days in New York City and 1 month upstate, which caused a little bit of confusion because 1 month it can be different than 30 days. Now, under the law from 2019, how much notice has to be given is a factor of how long the tenant has lived there. If they've lived there for less than a year, it's 30 days. Between 1 and 2 years, it's 60 days. And more than 2 years, it's 90 days. And again, like I said, the new law hasn't been tested that much, especially up here. So these kind of new requirements, I think, are mistakes are made by landlords and their attorneys on these things. I guess less and less over time, but they still happen because it's still fairly new. Uh, Again, licensees or squatters get 10-day notices. You know, if they're actually a squatter. I mean, there's a municipality here in the area, and I won't name, that they had landlords not paying taxes, and so they wanted to evict the tenants to get them out of there because the taxes weren't being paid. So it's kind of incident to a tax foreclosure, and they would call everybody squatters in the notice. They say, you're a squatter, you don't have any right to be there. And these are people that were, you know, sometimes tenants with leases, been there for years. So like I said, the squatter thing is really, I guess it sounds good because of TV and movies and stuff, but really it's not the reality most of the time, but it's thrown around a lot. I guess it's a pejorative term or something. The notice to cure is generally set out by the lease. Usually you don't have a right to cure unless you're in some sort of regulated housing that specifically requires it, or the lease requires it. And the lease, of course, requiring is more common. And again, this slide is repetitive, but you know, you have to wait until the cure period expires, and then and establish that the tenant didn't do what they were, didn't cure what they were required to cure, and then you can move forward, like I said, under the terms of the lease. As I mentioned earlier, the pleadings in a summary proceeding are basically a notice of petition and petition. Notice of petition serves as a summons to tell you you've been sued and where you have to show up and what's going to happen if you don't show up. And the petition is the document that sets out the allegations and the nature of the relationship between the parties and the allegations and why the petitioner is entitled to a warrant of eviction. The notice of petition can only be issued, which means signed, by an attorney, a judge, or a clerk of the court. We've had cases, a few out in the rural areas where courts let landlords sign notice of petitions. And that's a fatal defect, but I've seen it happen quite a few times. In fact, one of the first cases I had as a supervisor in New York involved a situation where the landlord signed the notice of petition. And I think we were able to get it dismissed, as we should. Here's what's required in the petition. I'm not going to go through every one of them, but this is all in your materials. We argue, or we talk about arguing, at least at a minimum, what the result is of a petition that doesn't have all of these factors. I don't know of, and it doesn't mean there isn't any, but I'm not aware of any cases that basically say that you know, if you don't have one of these requirements, it's a basis for dismissal. Seems like it should be, but I don't know that there's law on that point. So not only do they have to have they have to allege certain things in a petition, but under 721 of the RPAPL, it has to be somebody who is authorized to bring a summary proceeding. Like one thing that we see is like agents used to be able to bring evictions, and now they specifically, I think, can't by statute, but they do anyway. You know, they send the landlord lives in New York City, so they send their local property manager to go represent them, which they can't do. So that happens on occasion. Methods of service, I mentioned this earlier when I was talking about the rent demand. Under RPAPL 735, it's pretty straightforward. If you get personal service of the notice of petition and petition on the tenant, then that's the date of service. If you don't find them at home or they don't come to the door, then you have to either post it in a conspicuous place or hand it to somebody who's a person of suitable age and discretion. And then you have to mail it within 1 day by both regular mail and certified mail. There's a lot of defenses that are packed into these. Sometimes there are issues of tenants will call our office after they've made their first appearance. And there's a question as to whether these defenses that go to personal jurisdiction are waived because personal jurisdiction is waivable. I think it's safe to say that here in the law school environment. I was in a law school a long time ago, but I don't think that's changed at all. So, you know, the affidavits of service are just a gold mine for information for a tenant's lawyer to kind of look through to make sure that, you know, the information is accurate and to look at how it was served and when it was filed and all that kind of thing, and to determine date of service. Because there, and we'll talk about this in a minute, there are a certain number of days that have to pass between service and the court proceeding. And so if it's too little or too much, then you can argue. It's the weirdest thing. It has this little screen in the corner that has me in it. And is it? better watch what I say. No deniability here, huh? So, and here's the next slide. So it used to be, you had to be between 5 and 12 days between service and the hearing. Now it's 10 to 17. The legislature basically has taken this process from being really fast to being like kind of fast. And I don't know for sure. I think Nick was involved in that in her prior life, but I think it's to stretch out the proceedings so that tenants have more time to figure out what to do and to find a place to go in the middle of an affordable housing crisis that nobody seems to be in the process of resolving that I can see. So obviously those kind of changes to give us more time and to give the tenants more time to decide what they want to do, to try to find a place when there aren't very many affordable places out there for low income people. So it's a great thing. Not for landlords attorneys, they hate it, which usually means by definition, we don't. So answering the petition, it used to be they had this weird thing where you have to, if you were served a certain number of days before the hearing, you had to submit an answer before you appeared. I think all of that is gone now. You can file an answer in writing or verbally when you go to court. You know, a lot of times when you go to court, I always train new lawyers, you know, be ready when you go up there, because some judges will say, okay, you know, how do you respond to the petition? What's your answer? And they want you to go through and say, okay, we deny 1, we deny 2, we deny 3, we admit, and they want you to do that. And so you have to kind of be ready for that. It doesn't happen a lot, but I have seen that where, okay, you guys aren't settling it. What's your answer? What are you saying? And then, you know, obviously you can interpose a motion to dismiss. Then if you want to, if you have a basis for it. This is an overview of some of the defenses that we're going to be going through. And actually, I should be spending the majority of my time on that. So I think we're right on the timed agenda. How exciting. So these are the defenses we're going to be going through faster than I want to, but improper service, like we talked about, you should raise that at the first appearance. Arguably, it's waived if you don't. And that, you know, that gets to be sticky because we'll have clients call our office the day before their hearing, and a secretary will call me and say, what do we do? You know, we're not going to be able to have anybody who's going to be able to talk to the tenant and assess it. And we say, well, you know, tell them to ask for an adjournment. And over time, I think it's tell them to ask for an adjournment and tell them to write this down to tell the judge they want to preserve all of their defenses. Because if they get an adjournment and then we decide to jump in, we look at the papers, we find these defenses that are arguably waivable and get in there later, and then you're kind of subject to, no, that was waived. If you have a sympathetic judge who would give some latitude to somebody who appeared pro se and who now has counsel, you know, I think most judges don't expect that tenants are going to be able to come up with a lot of these defenses. They're not trained to. I mean, I couldn't perform surgery on anybody in this room right now because I'm not trained to do it. So that's the kind of a concern, because there are people that, even though it's a fast process, it's not as fast as it used to be. There are still times where, you know, there's not enough time to kind of get the case around to go on the initial appearance. So there's a 1017 rule under 733 that I talked about. The manner of service, like I said, you're looking at those, you know, one of the first things you do if you get a case is to get the court file and you get the affidavits of service and you comb them, because there can be mistakes. I mean, they're also, you know, somebody says, you know, our client's 5'8", 160 pounds, and they're sitting in your office and, you know, they're like 6'2", 250 or something like that. And so that happens sometimes. There are people who do like bogus affidavits and things like that, or they put down who they expected they were going to serve and then didn't serve that person, and then they don't change it before they file it with the court. They're also, it's like the manner of service, how they did it. You know, they served it on a 9-year-old, something like that, or they served it on somebody who doesn't live there. In summary proceedings, the substitute service has to be on somebody who actually resides there or at a place of business as somebody who works there. I don't think that's true in normal civil proceedings under the CPLR, but in summary proceedings, it is, and we're able to interpose defenses on that basis. Subject matter jurisdiction. In the strictest sense, that relates to, and some judges I think have seen that and very narrowly in that, you know, we have subject matter jurisdiction. This property is in the city of Albany. We're Albany City Court. You're good to go. So that's one of the bases. We actually were looking at this because just recently in the case that we're handling, because the tenant has a Water of Lead address, but it's in the town of Connolly, and the case was filed in the town of Connolly. And so I told the person who works, who I supervise, well, let's figure out, is this in the city of Water of Lead, such that it should have been filed in Water of Lead City Court, which may generally, theoretically, we might want to be in as opposed to Colony Town Court. And I think we determined by figuring out where the property tax is paid, that it is properly in Colony Town Court, unfortunately. So that does come up on occasion when you get these places that are like on the border of one county or the other. And then you get, you know, the municipalities like Water of Lead and Cohoes, not Cohoes, but Water of Lead, you know, it's overlaid by the town of Colony that it's in. So that does come up sometimes, not a lot, but on occasion. The core of the dispute, the summary proceeding is supposed to be just about recovering real property, you know, not into issues of possession. When someone passes away, you know, it's not, you don't get involved in estate stuff. If there's a dispute about ownership, you don't get involved in any of that. It's just for possession and who has the right to possess the property, whether it be the landlord or the tenant. The first section here on defenses is these are applicable to both non-payment and holdover. The improper petitioner is something that we argue a lot, actually. And it comes up in some instances where we'll find out that an LLC owns the property, but the lease and the petition are in the name of some individual. And so it's like, well, that's not the right petitioner. The petitioner should be the owner and the lessor, both. I think there are cases sometimes that say it's okay to have one or the other, but I know there's at least one case that requires both. So we, you know, that's what we usually argue. So that, and that can come up when you have a written lease and you have, you know, you can see who's identified, where it's the LLC or a person. And sometimes this happens with spouses too, like the property's entitled in the one spouse's name, the lease is in the one spouse's name, and for whatever reason, the other spouse files and signs off as a petitioner. That would be a basis to argue for dismissal. Defective verification, anybody who I've ever supervised know that I love this defense way more than any judges that we go in front of do. So I still mention it in passing, but I think it's interesting to me because when I was in Ohio, there was no such thing as verified pleadings. So when I found this, you know, when I came here, I thought, oh, this is really cool. This is kind of like new thing to be able to throw out there. There are cases that say that if the verification is not done correctly, that's a basis for dismissal. But I don't know that we have any courts, even the best courts for us, that will do that. You know, they'll overlook things like that, especially if you got a tenant in there that hasn't paid rent for 9 months. You know, they're going to say, nah, I don't think so. It's still there, but it's not very popular except with me. Again, RPAPL 741 lays out what the petition has to set out. One thing in that, and Chris just left, but he just got a good decision from a town court where, like, if you've got somebody who's got a housing choice voucher, so they're working with a local Section 8 office and there's an eviction, the landlord's supposed to plead that there's a Section 8 voucher involved in the petition, and they're also supposed to serve the housing authority that's administering the Section 8 voucher. And that doesn't always happen. And like I said, Chris, who just walked out, just got a decision from a town court dismissing a petition on that basis. Necessary party is also something that we argue a lot. It has to basically, the situation comes up where you've got a couple that lives in a place and maybe both signed the lease or one signed the lease. And then for some reason, the landlord only names and sues one of them. If the other person lives there, especially if they're on the lease, there's an argument that they're a necessary party and that the case should be dismissed because they didn't name everybody whose interests are going to be affected by the litigation. The new RPAPL 749 really helps us with this argument because it used to say when executing a warrant that the sheriff or the marshal or officer should remove all persons. Now it says remove all persons named in the proceeding. So, you know, you can argue to the landlord's attorney, you really want to go through all this, get a warrant and evict my client, but then leave her partner there because you didn't name him and serve him. And it creates, I think, and you know, I haven't done a deep dive into this, but I think theoretically at least creates a problem for law enforcement because they go there, they've got this warrant, it only has one person's name. And what do? I think in the past, they would just say, no, you're all the heck out of here. But now it's questionable as to whether they can really do that. And again, that really bolsters the necessary party defense, because now it's like they're not named in the proceeding. We have people who call us and say, the sheriff's here, what do I do? And we'll say, tell them that you look at the paperwork, your name isn't on there. So, you know, you could stay there. And of course, landlords hate this because, you know, if it's a couple and the one gets evicted and the one stays, well, you know what happens the next night or that night, you know, they're back in there. It's like the eviction never happened. So it's kind of surprises me that generally speaking, landlords, attorneys don't pay closer attention to that. It's not really that hard to name another person and to serve them. But this comes up quite a bit. It always seems to me that one of the questions that I ask the people that I work with, and if they say that there's a defense, is, did the landlord know that the person we're saying is a necessary party lived there? And I don't know if it's any specifically in any of the cases, but it just seems, it's always seemed kind of common sense to me that the landlord can't sue and serve somebody that they didn't know was there. And so, yeah, sure, Stu, go ahead.
I have seen landlords attorneys move in court to amend the active petition to include another family members or household members.
Well, and the amendment of petitions is just kind of the wild, wild west. They let them do it all the time, but they shouldn't be able to do that because that person is a necessary party. They didn't get a predicate notice. So you're just going to throw them into the lawsuit now, especially if they show up, but they didn't get served with, you know, the rent demand supposed to tell them, you know, how much you owe and give them the option to try either pay or they didn't get any of that. And it's a, you know, it's a jurisdictional prerequisite. So I guess depending on the circumstances, I would say we should fight that because it's wrong. It doesn't mean it doesn't happen all the time, because it does. It's a good point, Stu. Again, failure to plead and serve the Section 8 office. I just talked about that a minute ago. It's oddly enough, it doesn't apply to DSS, which is really kind of strange because the Section 8 office is sending some or all of the rent to the landlord, just like DSS is, but I don't know of any cases that applies it to DSS. It would be nice if it applied to all of the government agencies that are assisting with rent payments, because it would obviously provide defenses in more instances. Premature petition filing. There's this case that I don't even know was an eviction, but the notice doesn't run out. And this happens a lot because especially pro se landlords, and they have to give a 90-day notice. That's a long time to wait for somebody that you really want to get out of there. So sometimes, especially if they don't consult with a lawyer, they'll file on day 85 and boom, you got them. And then you get it dismissed and then you can say, hey, you got to start all over again. So yeah, that 3 months is a long time. Well, 6 is going to be even longer, you know? So anyway, that happens on occasion. And same with rent demands with 14 days, you know, they don't realize when the service is effective, or they will just jump the gun because they're anxious to get the person out. You know, it's like the beginning of the month, they're not getting their rent again. They really want to get it. So those are pretty straightforward and should lead to dismissal. And something that I always check for and tell the people that I supervise to check for, because it does happen on occasion. Non-payment defenses. Payment is always the best one, and that seems obvious. But you have to prove it, just like anything else. You know, we tell clients it's not what happened that matters when you get into court, it's what you can prove happened. And you know, we have a lot of people still that pay rent with cash and don't get a receipt. And I used to tell clients when I was a staff attorney that just take your rent money and just flush it right down the toilet. It's the same effect, because when you go into most courts and you're saying, I paid the rent, and the landlord's saying, no, they didn't. And the judge says, tenant, where's your receipt? And they say, I don't have one. Boom, it's over. You didn't pay. So we're finding now that even though there are still a lot of people that pay with cash, which is like something I always advise people, don't ever do that. If you do, you have to get a receipt. But there's, you know, now there's Venmo and there's PayPal and there's Cash App. And I think that there are variations as far as what kind of documentation you can generate when you make a payment in that form. I'm familiar with Venmo and PayPal, but we've had a lot of clients that use Cash App, which I'm not really that familiar with. One thing I know a lot of times when we have clients who will pay money, who pay something they intend to be rent, and then the landlord will take it and apply it to fees. Again, that there's one lawyer around here that does this a lot. And so we have tell tenants, well, earmark your payment. say this is for June 2023 rent, and they have to apply it that way. Well, in some of these apps that they pay for, there's no way to add like a memo or whatever, it's like a check. And so we always tell people, well, send an email right after you make the payment and say, I just sent a payment through Cash App. I want you to apply it to, this is for September 2023 rent. The problem is that people don't know to do that. And by the time they get to us, it's too late. So, but that is so payment seems like it should be straightforward, but it isn't. Tendering a payment that's refused, that can get dicey as to what constitutes a tender. If you pay all the rent or the costs anytime before the proceeding or during the proceeding, then that's the end of it. We have had situations, especially in the smaller towns, where the tenant says, I have all the money right here. Here's all the rent money and the filing fee. And the landlord will say, I don't want your money. I just want you out. And of course, if we're there, we say, Judge, this is a non-payment proceeding. Payment over. But they'll say, well, I'm not going to make the landlord take the payment. They don't want to rent to him anymore. Which is an interesting personal perspective, but it's not what the law is. But that happens. So that could be a little dicey. There's source of income discrimination, which is great. Landlords can't refuse payment because they can't say, I don't take Section 8, I don't take DSS. The only issue with this is that it doesn't really give you a lot. It gives you the right to file a complaint with DHR that they'll investigate. But and I think in some states, they might allow that as a defense. There's been some traffic on the National Housing Listserv about that. I don't know that there are any cases in New York, but I would love if somebody, whether in this room or not, would establish that, because it's rampant. You still see people, I don't take DSS, I'm not filling out the forms. When we have financial assistance at legal aid, I'm not going to fill out the forms that you need to pay me. That's all sorts of income discrimination. But like I said, it gets you the right to file a complaint with DHR. That doesn't keep you from getting evicted. So it's helpful to have it there. It'd be even more helpful if there was something that specifically said that it was a defense in an eviction proceeding. Even if the landlord refuses, proper evidence of the court will render proceeding moot and a decision in favor of the tenant. I wrote that, I guess, must have been in quite an optimistic frame of mind, because that is only dependent on the judge that you're arguing in front of. The 5-day reminder, which is a new requirement by certified mail, is a defense if they don't do that. It's strange, people get confused with the 5-day notice. The 5 days has to pass before the notice. With all the other notices, the time passes after the notice. So, and these notices can be, a lot of times you have notices that have to be sequential. These don't have to be. And so, the tenant will get the 5-day reminder saying, hey, you didn't pay your rent for September, pay it, or I'm going to take further action. And then a couple of days later, they get this rent demand, which has more information in it. And landlords get confused by it too. But if there's a no 5-day reminder, no demand for rent, or it's improper, it doesn't have all the information that's required to have, those are all bases for dismissal. The summary proceedings, again, can be, a non-payment can only be based on the non-payment of rent. And they're not under 702, they're not supposed to even seek it. But we still see rent demands and petitions with all those things that I talked about in the baked potato earlier, the usually late fees and attorney's fees. And again, it's ambiguous because the attorney's fee statute was amended to say there's no attorney's fees in a default, which seems to imply that there are attorney's fees that are allowed somehow. And that really just gets to be confusing. And I wish that the courts would clarify to say rent means rent means rent. That's what the statute says. But we're not there yet. In Albany and should be in other places too, you have to have a residential occupancy permit to bring a non-payment. Some places call it certificate of occupancy. Some people in Albany, it's the ROP, residential occupancy permit. And now because of the multiple residence law, I don't know that a lot of people know that's expanded that to everywhere. But, we've been arguing that because of this Albany ordinance in Albany City Court for years and years, and it usually works. But we tried it, I think, in other courts because of this new multiple residence law section. And they'll say, well, we're not in Albany. Well, we're in New York though, right? So it should apply. But again, it's educating the judges on that, bringing copies of it, showing it to them. So we're not where we should be with some of these new laws. Like I said, if you're in the city of Albany and there's no ROP that you can check with code enforcement and find out there isn't one, then you're going to get a dismissal or it's at a minimum basis to leverage a favorable settlement for your client. Other courts, because with this new law, I think is a work in progress. Defense is the holdover proceedings. One of the main ones is acceptance of rent. And sometimes you'll have judges or landlords attorneys say, this is a holdover. This isn't about rent, which is interesting. But if you accept rent in what we call the window, after the termination notice expires and before the proceeding is commenced. And I believe in city court, the proceeding is commenced with filing, and in town and village courts, it's commenced with service. So there is a difference between of commencement, looking at the City Court Act and the Uniform Justice Court Act. There's a difference there. But if the landlord accepts future rent in that window, say they give a termination notice, I want you out by August 31st. They file in September 10th. If the tenant paid between the 1st and the 9th for September rent, again, earmarking is important. If hopefully they know to do it, then that's a basis, that's a defense, because, on the one hand, the landlord's saying, I want you out. And on the other hand, I want your money, and they can't have both. Now, if they accept the money after the petition is filed or the proceeding is commenced, they're fine. But in that window, and that's, you have a defense. It's a good defense. And actually, other people in here might not agree, but I think it's one of the defenses that judges accept fairly regularly, more than others. It's pretty easy to understand. The law is very clear in that regard. There are also objectionable tenancy holdovers, again, which is, I talked about earlier, governed by the terms of a written lease. And, the written lease can say this is objectionable behavior, making noise all hours of the night when your neighbors are trying to sleep. So I got to go to work, that kind of thing. Again, very heavily reliant on a written lease. If there's no written lease, there's no way to do this. And you'll have landlords that say, what do you mean, Your Honor? You mean they can just continue to have this abhorrent behavior that's affecting all these other people and no one wants to rent in my building now? It's like, do a written lease that specifically says that you can evict for that. The proper termination notice, again, I talked about the 30, 60, 90. If they don't give the right notice, then they have to start all over again because they didn't properly terminate the tenancy. Lack of specificity in the notice of the petition. If it's based on a breach of the lease, there has to be specificity in what the landlord is alleging that the tenant did to want them to evict them. And we'll see these where it said they violated paragraph 7 of the lease. And you look at 7 and it's got like 12 different things that could get you here, and you can't defend it because you don't know what the heck they're alleging. And that's why this law is there. I don't think judges like this that much, but it's in the petition. I mean, it's in the notice and in the petition itself, which is pretty unique. A lot of times these defenses either relate to the notice or the petition. Rarely does it apply to both, and this defense does. Warranty of habitability, I could probably spend 3 hours on this alone. So I see my time is running down. The warranty of habitability and retaliation, I find, hesitate to say this, I mean, Nick's here and everything, but I think that people the word on the street makes these defenses way more popular than they are effective when you're arguing a defense to an eviction, because with warranty of habitability, you have to prove it, but you also have to hold on to the rent, because you're going to have a judge who's going to say, if you have a habitability hearing, you argue that there are all these conditions, the landlord didn't repair it, tenant didn't cause them. And so I think the rental value is $400 instead of $800. Well, if the judge disagrees and say, yeah, I see that you got this there, I'm going to give you a 20% abatement. So whatever 20% of 800 is, that's what you have to pay. And if you don't pay it, we're going to issue a warrant of eviction. So a lot of times people confuse withholding rent with not paying. So if you go to court and you get a 25% abatement, you got to have the money to pay that 75%, or you're going to get evicted like you didn't have a warranty of habitability claim, except any money judgment against you might be reduced. So it's a defense. It's there. You can get pictures and you could prove it, and it can reduce the rent. But if the tenant didn't hold on to the money to pay whatever the court determines is due, it doesn't help you that much. Now, we've been involved in this recently in this project or complex over in Troy, where 135 people were evicted by the city because of deteriorating conditions with the wall and all that stuff. In that situation, you know, if you got a condemnation there's an argument that there's no rental value. Same with a constructive eviction. If you actually move out, there's no rental value. Then, you know, you have a stronger argument. But most of them, people will come in with, you know, there's a hole in the screen, the window's broken, some stuff that is more serious, you know, sewage backing up in the basement, or you know, you've got a tenant in there with a bunch of little kids, and the front door lock is broken, so it's not safe. So you can prove these things and you can get those reductions, but again, you have to have the money. So I'm going to skip through that in the interest of time. Retaliation is kind of the same thing. The new law in 2019, I don't know how long I can call it new, maybe 5 years since the pandemic kind of reduced to, you know, shut the courts down. But in any event, it's expanded the acts of the tenant that can be subject to a retaliation defense or counterclaim. And it also has increased from 6 months to 1 year, the rebuttable presumption that if an eviction is bought within that period of time after a tenant does basically a protected act, it's presumed to be retaliation. These defenses, a lot of times clients will want them. I called code enforcement. Yeah, well, you're behind 6 months in rent. And the way the retaliation works in practice, so we haven't seen it a lot. It's a lot more popular kind of in conversations than it is in courtrooms. But, you know, you go in there and if it's a non-payment, you say I called code enforcement. And then right after that, he gave me this rent demand. And then the burden shifts to the landlord to prove a non-retaliatory reason for filing, and said, well, I didn't file the eviction or give them the notice because they called code enforcement. I filed it because they haven't paid rent in 6 months. And then there's really nowhere to go as a tenant, because then it's like, what are you going to say? It's much better in holdovers because they can't just pull out that non-payment of rent. You can really get into having evidence about whether it was retaliation or whether there was a non-retaliatory reason. Hardship stays are something that is new for upstate. You can get an eviction stayed for up to a year under certain circumstances. You've got somebody who's ill, or you've got somebody looking around to try to find a place and they can't find one, or child's enrollment in a local school. So that's just another tool for us to play with. And I don't know that I've seen any judge stay proceedings for a whole year, but we have had cancer patients that are in chemo that we ask the court to give them like an extra 60 days, and that often will work. The other thing that's interesting is this last piece on this slide, which is if you get evicted based on a breach of a lease, the law requires now that warrant of eviction be stayed for 30 days to allow the tenant to cure it. And that can be good. You know, somebody lives there or somebody's making noise and they stop, or the person moves out or whatever. If somebody breaches a lease by committing a crime, allegedly, how do you cure that? So there is some question in my mind, at least, as to how that works. But it's really good to have that there because, and I think we actually had a case recently where we had an elderly client whose housekeeping was horrific. Not actually white glove test horrific, but actually horrific. And we were able to get a stay to give him time to get an agency to come in and help him clean his apartment and beat the eviction. So that's a nice thing to have. It's great. It's very welcome. Where are we at? 6 minutes. Okay. So at the hearing, if you're in most city courts, when you go to court, you do the initial appearance. There's an initial appearance. The case is either settled, or it's adjourned, or it's dismissed, or it's set for trial. In some of the other places, like I started out here working in Amsterdam, and you go to Amsterdam City Court, if you don't settle that case, you're having a hearing like now. At least that's the way it used to be. And you know, the courts around here, they don't do that. They have this initial appearance and then they'll set it for later. But you always have to kind of be ready because you don't know, you know, a visiting judge could come in and say, settle it, you know, okay, we're going to move to dismiss. That's denied. And then it's call your first witness. And it's like, whoa, what happened to the initial appearance? It doesn't happen often, but more in a town and justice courts who only have like eviction court once a month. They're not going to want to talk about it now and then litigate it in a month. A lot of times you just do it all right there. So, you know, most of our practice is in city courts, so we are used to the initial appearances and then going later on for because it was adjourned or because they set it for a trial. But you can't always assume that that's what's going to happen. Again, the new part of this is that you used to be, if you wanted an adjournment, it was up to the discretion of the court. Now, if you raise a tribal issue of fact, you automatically have the right to a 14-day adjournment, which is great for us. Any subsequent adjournments are again of the discretion of the court. But the first adjournment, as long as there's a tribal issue of fact, is no longer discretionary. Basically, at hearings, ultimately, if the tenant loses, there's often not a written decision, but there is an issuance of a warrant of eviction, which can be stayed to a later date. Sometimes that's that's from the court. Sometimes it's a settlement, like the tenant wants to move, but they need some time, and so it's like, all right, we'll agree to a warrant of eviction, but we're going to stay it for 2 months so that the tenant has some time to find a place to go to. Trials are pretty much like any other trial in a civil case. Generally pretty liberal about the rules of evidence that we just heard about. Warrants of eviction are obviously something that we're trying to avoid all the time. They have to be served by a law enforcement person, which is a sheriff or marshal. Sometimes landlords will try to do this themselves. We've even seen landlords that will manufacture bogus warrants and try to serve them on tenants and stuff. That's always fun to kind of work through. The warrants now have to state the earliest date upon which execution can occur, and again, can only be enforced against people who are actually named and served. Used to be you had 3 days to vacate after you got the warrant. Now you have 14. So it went from 3 to 14 on the predicate end, and it went from 3 to 14 on the back end, which is obviously very helpful. We have tenants that'll call us at any stage of the proceeding, again, including for the first time when the sheriff's at their door. So that 14 days is really helpful. It does not exclude weekends like it did when it was 3 days. Now it's just 14 straight calendar days. You can pay all the way up to the execution of the warrant. So the first time that the warrant comes out, that's the service of the warrant when we're given the warrant. And then when they come back, it's the execution. You can pay to the court anytime before the execution of the warrant, unless the landlord could show that the rent hadn't been paid before that in bad faith. I love it when these statutes are like this, because we have tenants that will go to court and say, hey, my lawyer told me that under this statute, I can go pay this money. And the clerk's like, we don't take money. We don't want your money. What are you doing here? And that happens like a lot, but there are quite a few statutes that provide for that. And I think even in the stay statute, in the stay, if you get that stay, you have to keep paying your rent. And I think it's into court, but courts don't want rent money. I don't think they have mechanisms for it. So it's a interesting provision. We usually just tell them pay the landlord in a way that you can prove you paid it. Because, you go to court, they're not going to want it, or they're not going to know why you're even offering it usually. Judgments are usually can also include a money judgment for unpaid rent. Sometimes they include fees, even though they shouldn't. Now you can do fees and settlements. I want to talk about settlements. I guess this is the last slide, so that's good. That basically, when you go to an initial appearance, where they have initial appearances, court wants you to settle. They say go out in the hallway, try to settle it. And oftentimes, we have clients who say, I don't want to contact that landlord. I don't want to deal with him. He hasn't fixed anything. He's a jerk to me. He was mean to my kid, whatever. And it's almost always a good thing to discuss settlement, because oftentimes, especially in this context, you get a better deal from settlement than you get from the judge. That's not always true, but generally it is. And I always tell clients, you can do whatever you want. We're lawyers. We'll go to a trial if you need to. That's what we do. But oftentimes in settlements, you'll have some control over the outcome. When it's decided by the court, I have some input on the outcome, but nobody has control over the outcome except the judge. In the settlement, both parties do. And I guess they always say that if you have a settlement that nobody likes, it's probably a pretty good settlement. So there's that. What we often do, if we have procedural defenses that we don't know if the judge is going to buy or not, we'll use those to leverage whatever the client wants, whether they want to get rid of the money judgment because they don't want their wages garnished, or they want more time to move, or they want more time to pay the rent because they're expecting money coming in, anything like that. And oftentimes you can get landlords to waive back rent or to agree to adjourn the case until the tenant can go try to get money from DSS or a social service agency, because oftentimes landlords just, want the money so they can pay their bills or for whatever reason. And if the tenant can if it takes a few more weeks in order for the tenant to get the money from somewhere else and the landlord's gonna get paid, oftentimes they'll agree to that. And it's 12:01.